review petition has been filed.
Has been filed. ಯಾವ್ದರ್ದು?
Filed on D9.
ಏನ್ ವಾಟ್ ರಿವ್ಯೂ?
Impleading application has been approved.
ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲ ಆಗಿದೆಯಾ?
The dependent came in a petition before the Supreme Court that
Other-
has allowed and impleading application has been.
What review in that?
Party has filed.
Huh?
Party has filed.
Party has filed ಅಂತ ತಗೋ. What is review in that? ಅಲ್ಲೋ ಹಾಗಿದ್ರೆ ಚಾಲೆಂಜ್ ಮಾಡಿ. That is not a ground for review at all. Anyway, ಬಂದ್ರೆ I will answer it. ಮೆಮೊ ಕೊಟ್ಟು next week ಯಾವಾಗ ಹಾಕಿ. Oh, that's not completed ಅಲ್ಲ? We'll fix it on 7th.
The further hearing matter, Your Lordship. Muda matter.
Muda?
Mandya Urban Department.
ಮಂಡ್ಯ.
Your Lordships have pleased to quash the proceedings against accused number 5. 4 and 6 also had preferred a petition before Your Lordship, which was deferred.
That was pending in the Supreme Court, madam.
Now that has been dismissed, Your Lordship.
SLP is
Your
rejected?
Lordship- Yes, Your Lordship.
Order is confirmed.
Order is confirmed.
All right.
Further hearing.
7th. SLP have dismissed ಆಯ್ತು, ಪೆಂಡಿಂಗ್ ಇತ್ತಲ್ಲ?
Pending it, dismiss ಆಗಿದೆ. Pronouncement of order.
Bill number 1.
Allowed cost.
Number 2.
I request Your Lordships to give registry, be directed to release him on, he is in custody, Your Lordship. Direction.
Quash ಆದ್ಮೇಲೆ consequences for it, that's not the prayer here.
That is not it, but if there is no direction, jail authorities would not be.
No, that mean consequence, you will be entitled all consequential release. Quash ಆದ್ಮೇಲೆ ಏನು ಉಳಿತು? Yes. ಅಲ್ಲೂ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಡಿ, ಕ್ವಾಶ್ ಆದ್ಮೇಲೆ ಸಾಕು. 3 ವರ್ಷದಿಂದ ಜೈಲ್ ಇಡಿಸಿದ್ದೀರಾ, ಸಾಕಲ್ಲ. ಯು ಮಸ್ಟ್ ಬಿ ಸ್ಯಾಟಿಸ್ಫೈಡ್ ನಾವು. ಇನ್ನೊಂದು ಹಾಕಿದ್ದೀರಾ?
ಇನ್ನೊಂದು ಇಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ರೆಫರ್ ಮಾಡಿ.
ನೀವೇ ಕಂಪ್ಲೇಂಟಾ?
ನಾವು ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಇಸ್ ಅ ಕಂಪ್ಲೇಂಟ್.
ಈ ಕೇಸ್ ಅಲ್ಲ? ವೈ?
Suppression of the
Separate crime is registered and trial is going on.
That's I have quashed the crime.
Number 2.
The petition is
Finding no merit in the petition stands rejected. Suit is of the year 2002. 23 years have passed by. This revision petition is preferred in the year 2014. 11 years have passed by. Therefore, I deem it appropriate to infuse finality into the proceedings. The concerned court shall make all endeavor to conclude this suit/proceedings with an outer limit of 6 months from the date of receipt of the copy of this order.
3.
Dismissed.
4.
Dismissed.
5.
The petition is allowed in part mandamus issues to the respondents to release the amount that is claimed by the petitioner through the bills so submitted within an outer limit of 4 weeks from the date of receipt of the copy of the order. ನಾಗಬಂದಾಸ್ ಕಮಿಟಿಲಿ ಒಂದು ಅಕ್ಷರ ಇಲ್ಲ ಇವ್ರ ಮೇಲೆ, ಮತ್ತೆ ಅದನ್ನೇ ಇಟ್ಕೊಂಡು ಕೂತ್ಕೋಬೇಡಿ. Yes. Next.
6.
Allowed cost. This is day before yesterday's matter. Day before yesterday's matter. Where is Jagdish? Mike? On ಮಾಡಿ.
He's engaged.
Engaged elsewhere?
In a different court. I've informed him about it. Lordship meeting.
Pass over?
same
Eight.
cat case, my lord.
25 ದೇನೋ?
My lord,
Seal number 8, 7 ಆಯ್ತು 8?
8, my lord.
Eight, Lord.
It's a new fresh case, my lord.
ಹಾ.
But crime stage ಅಲ್ಲಿ investigation officer has done the reverse merger, my lord, wherein he takes the complainant to the accused house for the mahazar. ಅಲ್ಲಿ ಇವ್ರ ಗೋಲ್ಡ್ ನ ಬಿಚ್ಚಿಸಿ ಅವ್ರು ಕೊಟ್ಬಿಟ್ಟು ಅವ್ರ ಗೋಲ್ಡ್ ನ PF ಮಾಡಿ, this is what he has done, my lord, the investigating officer, my lord. Because of that, and before this court, because the writ petition it was before this
ನಂಬರ್
court,
ಹೇಳಿ,
it was
ಇನ್ನೊಂದು
quashed.
ನಂಬರ್, ಇನ್ನೊಂದು ನಂಬರ್, ಇನ್ನೊಂದು ಪೆಟಿಷನ್ ನಂಬರ್ ಹೇಳಿ.
My lord, that has been quashed, my lord. WP 331398, my lord.
ಅದು ಹಸ್ಬೆಂಡ್ ಒಂದ್ರ ಮೇಲೆ ಮಾಡಿರಲಿಲ್ಲ.
Yes, my lord.
That is stayed by
Partly
Supreme
allowed.
Court. That is stayed by Supreme Court.
No, my lord. I have not gone to Supreme Court.
You, why will you go? ನಿಮ್ ಪರವಾಗಿ ಬರ್ದಿರೋ ಆರ್ಡರ್ ಅದು. ಎಸ್. ಇದ್ರಲ್ಲಿ ಏನೀಗ?
Regarding the maintainability, my lord, page number.
What maintainability?
My lord, the office objection is that.
That we will overrule. Office objection square maintainability stands overruled. A learned additional SPP is directed to accept notice for the respondent.
My lord, Panchnama is at page 52, my lord.
ಪರವಾಗಿಲ್ಲ, ಈಗೇನು ಸ್ಟೇ ಇಲ್ಲ ಇದ್ರಲ್ಲಿ. ಎಸ್.
My lord,
ಏನು?
my lord, gold release ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ, my lord.
Gold
The
release.
accused- Yes, my lord, this is my Sridhan, my lord, which was removed by the IO during the Mazar, my lord.
All right, we'll see.
Page 52, my lord, Panchnama.
The release of the PF pertaining to the subject crime shall not be, a release of the PF in favor of the accused shall not be done without the leave of the court till the next date of hearing.
Obliged.
Yes.
That's further hearing, my lord. Because this should come before your
ಇಲ್ಲೇ
lordship.
ಬರ್ಬೇಕಪ್ಪ. Yes, further ಏನ್ ಬೇಕಾಗಿಲ್ಲ. Yes.
Obliged.
Next.
Admission 9.
Madam, 1 to 5 full release ಮಾಡ್ಬಿಡಿ. 6 ಮಾತ್ರ ಬರ್ತದೆ.
The respondent is next. Case is ready, he could address
Password.
the arguments.
Password.
10.
Lordships have heard this case. With your lordship's permission, my lords, synopsis were prepared.
ಓ, ಮೊನ್ನೆ ಇರ್ಲಿಲ್ಲ ನೀವು.
I'm so sorry. I owe an apology.
22 years.
And also, my lord, my learned friend had told me that he pointed out that this was not ancestral property at all. But in all fairness, my lord, I must submit that ground was not raised in our application. It is now, I'm told, in the additional written statement that ground has been raised, that it was the self-acquired property
This is
of the mother.
711. 711 will answer 711 whether there can be a partition suit or not
Correct.
after 22 years or otherwise. Because law permits any number of partitions.
But only thing is, my lord, what I was pointing out was this property which is sought to be partitioned is, they was made a specific government now, of course, that it is the self-acquired property of my mother, and therefore could not form a part of the property that could have been subject matter of partition at all. And that 2004 also, although stylized as a partition, was more in the nature of a family settlement, which of course the plaintiff's husband was a part of. So, which of course he also did not question it during his lifetime. Now it is questioned after he passed away.
ಅದೇ.
It is that.
We'll ask the plaintiff. ಕೊಡಿ sir. Yes, sir.
Well, could we also be permitted to file our synopsis? Madam.
The propositor,
Ah,
but his wife is an Irama, Appaya and Irama, husband and wife. But they had 3 sons, namely Manjunatha, Renukananda Babu and P.A. Babu. But 3 sons, they were having.
one clarification.
Yes.
Was there any suit for partition earlier or it was a family partition only?
No, there was no suit for partition. But
There was
earlier-
no suit, earlier suit irlilla.
Earlier suit.
So this is amongst the members of the family or otherwise, this is the first suit for partition.
Yes.
All right.
One. Secondly, my lord, they are three, there are three sons and the father. And the first son, my lord, is Mr. Manjunath. And he is the only educated man. Other two persons, my lord, Renukananda and Babu, they are not educated and not worldly wise also. Now, Renukananda died issueless, without married. And Babu, my lord, he is married and he has wife and two minor children, that is Pratima and Likita. They are the plaintiff now, 1, 2 and 3.
ಇನ್ನೂ ಒಂದು ಕ್ಲಾರಿಫಿಕೇಶನ್.
Yes.
ಸೆಟಲ್ಮೆಂಟ್ ಆಗಲ್ವಾ?
ಸೆಟಲ್ಮೆಂಟ್ ನಾವು ಹೇಳಿದ್ವಿ, ಅವರು my instructions are they're having about 175 flats.
ಯಾರು ಇವರು?
And yes, they have lost properties. Giant development they have given about 125 or 175 flats they have constructed. 50% they have taken. Some have been sold. Again another 65 flats they have been constructing. What I said is some reasonable settlement we are agreeable. They are giving only 20 lakhs rupees. They said it is not agreeable. Our client said if at least I must get some reasonable.
20 lakhs for each of the children.
50%. Will actually kindly say 50%. Suppose, my lord, if I succeed, she is entitled for 50% because one brother died, and mother, father, everyone has died. Only and they what they are claiming is
ಎಷ್ಟು ಫ್ಲಾಟ್ಸ್ ಇದೆ?
50% ಬರಲ್ಲ,
No.
as per the family tree itself.
Whatever
There
it
are other
will-
children.
ಎಷ್ಟು ಫ್ಲಾಟ್ಸ್ ಇದೆ?
no according to
We'll answer it on merits. It's a different thing.
about 160 flats ಇದೆಯಂತೆ.
ನಿಮ್ಮ ಪ್ರಕಾರ ಎಷ್ಟಿದೆ?
40
ಫ್ಲಾಟ್ಸ್.
flats.
ಅಲ್ಲ 40 ಅಂದ್ರೆ ಅದನ್ನ ಮಾರಾಟ ಮಾಡಿ ಇನ್ನೊಂದು
Already sold.
ಅಪಾರ್ಟ್ಮೆಂಟ್ ಕಟ್ತಾ ಇದ್ದಾರೆ, ಇನ್ನೊಂದು ಅಪಾರ್ಟ್ಮೆಂಟ್ ಕಾಂಪ್ಲೆಕ್ಸ್.
Anyway, try to mediate and
Please.
close it. We'll give you 1 week's time.
But the problem is
ಒಂದು ವಾರ ಟೈಮ್ ಕೊಡ್ತೀನಿ, ಲಾಸ್ಟ್ ಪ್ರಯತ್ನ ಮಾಡಿ. ಇಲ್ಲ ಅಂದ್ರೆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ವಿಲ್ ಕನ್ಸಿಡರ್
As the last,
as a last option. All of you are
Reasonable,
members of the same family, ಮತ್ತೆ ಗಲಾಟೆ ಇಲ್ಲ.
yes sir, only
Close ಆಗುತ್ತೆ.
only brother and sister, only two brothers, no other persons. Others they have already settled. Obviously, eldest brother is having entire thing.
ಆಯ್ತು, let's see if settlement can be.
we'll put it forward. In fact, efforts have been made, but anyway, if it falls on the court, we will make an earnest attempt.
ಮರಳಿ ಯತ್ನವ ಮಾಡಿ. Yes. Yes, I'll take it on to 15 days time ಕೊಡ್ಲಾ? I'll take it on 14th.
Further
14th November. Same dictating orders like this. Yes, heard the learned senior counsel Vikram Holigol appearing for the petitioner and the learned senior counsel G. Krishnamurthy appearing for the petitioner. The parties to the list, this court is of the opinion that if reasonable time is granted to the parties, to the warring parties who are brothers and sisters, the settlement could be arrived at.
Brother and sister-in-law,
Brother and sister-in-law, the settlement could be arrived at between them. To enable them to have talks of settlement, list the matter on 14th November for further hearing at 2:30 PM.
Great.
Yes.
Number 11.
ಅದನ್ನ ಮೇಡಮ್ ಇದು
I'll just
ಹಾ
brief facts, my lord.
ಅವ್ರು ಹೇಳಿಲ್ಲ, ಮತ್ತೆ ನೀವ್ ಹೇಳೋದು. ಎಸ್ ಸರ್,
ಅವ್ರು ಮಾಡಿದೀನಿ ಅಂತ.
ಅವ್ರು ಮಾಡಿದ್ದಾರೆ, 2 ಸರಿ 3 ಸರಿ ಮಾಡಿದ್ದಾರೆ, ನೀವು ಮಾಡಿ.
ಫರ್ನಿಶಿಂಗ್
ಇದು ಗ್ರಾಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಯಾವಾಗಿಂದ?
My lord, one synopsis ಹಾಕಿದ್ದೀನಿ, that's it,
ಹಾಕಿದ್ದೀರಾ?
your lordship.
ನೀವು ಹೇಳಿ, ಅದಕ್ಕೆ ತಗೊಳ್ಳಿ ಮೇಡಮ್.
ಕಾಪಿ ನಮ್ಮದಲ್ಲ. The last occasion I filed one agreement of sale.
Agreement.
Agreement of sale is the first.
Now you are for the grantee, Bipin sir.
No, my lord, I am the, yes, my lord.
Grantee. Yes. Oh, date of grant,
My lord, 6/9/2000,
6/9, non-alienation.
15 years, my lord.
Grant under what?
My lord,
Land grant rules, yes,
Yes,
PTCL.
PTCL. With the condition of 15 years non-alienation,
Hmm.
which expires on 5/9/2015.
5/9/2000, agreement date.
Agreement, my lord, is entered on 16/6/2014.
Sale deed.
Sale deed
ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ. My lord,
Sale deed ಆಗಿಲ್ಲ.
general power of attorney,
Hmm.
GPA, my lord, is also on 16/6/2014.
There is one judgment of Justice Sandesh.
Yes, ma'am. My lord, I have given the judgments also, my lord.
A judgment ಅದರಲ್ಲಿ that was on the land grant rules on section 61 of the Land Reforms Act.
Yes, ma'am.
ಅದರಲ್ಲಿ
61.
agreement of sale ಆಗಿತ್ತು.
Yes, ma'am.
Sale deed ಆಗಿರ್ಲಿಲ್ಲ.
Yes, ma'am.
Unless sale deed happens, it would not violate the non-alienation clause ಅಂತ ಇದೆ. Because sale deed happens after the period was over.
If your lordship sees the CH-PTCL Act,
PTCL Act stands on a different footing,
because the definition of transfer
includes agreement.
sale agreement also. On that basis, my lord, the Supreme Court has held.
That I know.
Now, my lord, here, their only contention was before the court below that possession was not taken. Now, my lord, your lordship may kindly see the GPA also to show that possession has been taken and the entire right has been given them to sell also.
We'll see. Yes, Bhaskar.
Miller, let kindly produce the agreement of sale. I have produced it.
ಇವಾಗ ಕೊಟ್ಟಿದ್ದೀರಾ?
ನಾವು ಕೊಟ್ಟಿದ್ದೀವಿ, ಅವರು ಕೊಟ್ಟಿದ್ದಾರೆ.
In the list of documents I have produced, my lord, your lordship.
No, I have produced only document that is agreement.
Same, ಏನು change ಇಲ್ಲ.
ಒಂದೇ agreement ತಾನೆ?
One agreement.
Page?
My lord, in my list, my lord, page 3.
Page 3.
Page 3 of the synopsis which was filed. Page 3 is the.
ಇದು agreement ಅಲ್ಲ ಇದು grant certificate document number 1.
Document number 1.
Document number 2.
Miller, document separate ಆಗಿ ನಾನು ಬರೀ agreement of sale ಕೊಡ್ತೀನಿ. That would be easier.
ಆಯ್ತು.
Same sir ಅದು.
ಆಯ್ತು ಕೊಡಿ.
ಒಂದೇ ಆದ್ರೆ easy.
ಆಯ್ತು.
We'll take Bhaskar's only. Yes. ಮೆಮೊ ಹಾಕಿದ್ದೀರಾ ಭಾಸ್ಕರ್?
Yes, Miller.
ಅಲ್ಲ ಮೆಮೊ ಇಲ್ಲಿ.
ಇದೆ presentation form ಸಮೇತ.
ಅದು ಗೊತ್ತು.
I have given it in the court.
ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೆ.
ಕೊಡಿ ಇನ್ನೊಂದು ಕಾಪಿ ನಿಮ್ಮ
ಡೇಟ್ ಏನು?
Date I don't remember.
ಅದು ಬೇರೆ ಅಗ್ರಿಮೆಂಟ್ ಇದೆಯಾ? ಅದು ಇದು ಬೇರೆ?
ಇಲ್ಲ ಒಂದೇ agreement.
It's identical.
ಆಯ್ತು ಹೇಳಿ.
Kindly Paris para
16/6/2014 ಅಲ್ಲ? Para?
Page 6 of the, in page 6, para, page 5, Miller. Consideration. Rupees 7 point lakh.
27,50,000.
To the vendors complying all the terms of this agreement, including the permission being obtained from the government as prescribed under Karnataka Scheduled Caste and Scheduled Tribes Prohibition Act. The subject, the crux of the case, the agreement was to obtain the permission from the
Yes.
the next para 3 also, time for completion of sale. The vendors and the purchaser hereby specifically understand that the execution and registration of the sale deed shall be only upon permission being obtained from the government as prescribed under Karnataka Scheduled Caste. It is this is the clause which is written. Now, if the section reads, if we read the section, this agreement does not contravene any terms of the PTCL Act. Now, the Act, I'll read out that section. Section 4. Prohibition of transfer of granted lands, notwithstanding anything in any law, agreement, contract or instrument, any transfer of granted land made either before or after the commencement of this act in contravention of the terms of the grant of such land or the law providing for such grant. Now, any transfer which is made in violation of this act is what the interpretation can be made by reading section 4 of the act. Now, the judgments what I have produced before this honorable court today, division bench judgment of this honorable court, second judgment, Mila. Both, there are two division bench judgments, which is applicable to the case on hand, Mila. That is Ratnakar Hegede's judgment. Specifically, I want to read before this honorable court.
Yes.
Because there, the judgments relied upon by the petitioner herein, that is Supreme Court's judgment, has been interpreted by the division bench, saying that it is not applicable. In para 27, in para 26 and 27, in Srimati Narayanama and another versus Goindappa and others, the judgments relied upon by the respondents. The apex court was considering the case of a transfer under the provisions of Karnataka Land Reforms Act, which contained an absolute bar for transfer of land by a tenant in whose favor occupancy right has been granted. But the instant case is a case of a granted land under the grant rules in which there is no absolute bar as found in Karnataka Land Reforms Act. As stated earlier, the PTCL Act and the grant itself provide for a transfer of the land subject, however, to securing permission from the government. Next, that is para 27, Dharmanayaka and Ramanayaka. This is what the petitioners are relying upon. Reported in so and so, the apex court was dealing with a case of an agreement of sale which had been executed before the commencement of PTCL Act. And in that regard, the apex court took the view that the sale would not render section 4(1) inapplicable in the instant case, as the agreement of sale itself stipulated that the proposed transfer would happen on the government granting for transfer. The question of parties being in violation of the law would not arise. Now, this case, in this case also, the judgment what I am reading, there was an agreement. In the agreement, the provision, the condition was that they will execute the sale deed subject to obtaining the permission from the appropriate authority. Now, in my case, is the same scenario wherein both the parties have agreed that they will.
No, that was interpreting PTCL or land?
PTCL.
Yes.
Now, the division bench has made an observation that judgment is not applicable to the agreements of sale executed between the parties in the lands related to PTCL grants.
All right.
Wherein they admit and agree that they will obey the rules, regulations and acts as contemplated under PTCL Act. Here in our case, as I have read the agreement, the parties have admitted and agreed that they will get the sale deed executed only after obtaining the permission from the appropriate authority. Both the judgments. First judgment also deals with the same thing, and my case here is very much similar to the judgments relied upon by me. Whereas on the other side, on the other hand, the other side have relied on the judgments which are not applicable to the case on hand, Miller. Now, the recent Supreme Court judgment, third judgment, it clearly contemplates what is agreement of sale. Justice
53A interpret Madman.
53, 54 agreement of sale. That is
Arvind Kumar.
In GPA no saha it has been interpreted. Agreement of sale has been interpreted, though there is no particular observation with regard to the PTCL thing. Now, here 3E of this PTCL Act comes into operation only if the position of the land is given. Now, in my agreement of sale, position is not given. Kindly peruse position clause in the agreement. The position of the that is at page 7. The position of the scheduled property shall be delivered to the purchaser on the date of execution of the sale deed. The property is not transferred. Now, my prayer in the suit is also not only for execution of the registered sale deed. There are other multiple prayers. Now, order 7 rule 11D has been
that is rejected and that is questioned.
Reject. That is. Now, this is the crux of the matter, my lord.
Yes, anything else?
Lord, now your lordship may kindly turn to the documents which are submitted.
with regard to GPA, I have not made my submission. GPA is not a transfer, my lord. It is an authorization given to a part, a representation. Whatever is being done by the, would be done by the agent would be as good as done by the principal.
All right.
My lord, your lordship may kindly turn to page 11, my lord, document number 3.
ಇವತ್ತಿಂದ.
Earlier which I had filed.
Document number 3, yes.
Document number 3.
That is GPA.
GPA. This is also, my lord, executed on the same day of the sale agreement. Now your lordship may kindly turn to page 12. Witness as well has entered into agreement of sale of even date with so and so for a sale of scheduled property in terms of the aforesaid agreement of sale and in compliance thereof. We are by executing this power of attorney. Now in this power of attorney, my lord, your lordship may kindly see page 17. Annexure clause E.
I am there, yes.
My lord, to apply and obtain commencement
certificate,
certificate, completion certificate, occupancy certificate, other permission required for construction, completion and occupation of any building. To, my lord, G, to GL Madhyadale, modification of such demolition, construction of building in the scheduled property, apply for and obtain electrical, water, sanitary connection, and in that behalf, sign and execute all applications.
All nuances of ownership.
One minute. Annexure H, to construct building structure as per the sanction plan, execute any projects in the scheduled property at the cost of. So I'm trying to say possession has been given. Now, my lord, for that, my lord, clearly it has been said, next page, clause K, to apply and obtain layout plan sanction from the jurisdiction planning authority, including power of release, relinquishing the area forming part of the road, civic community site, park, including presentation, to enter into an assignment agreement, agreement of sale of scheduled property, or any portion shares thereof, enter into so and so, to transfer, convey by sale, gift, release, exchange, to receive consideration for the sale transfer. My lord, all this, now my lord, last clause is, my lord, page 20.
To hand over possession.
To hand over possession.
Clause yes.
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 Now, my lord, now the judgment which is relied by my learned friend, that is a division bench of justice.
G. Narendra.
Justice Narendra. Now your lordship may kindly look into that. Now what they say, my lord, there also, order 7, rule 11D, it was allowed. There, my lord, the court came to the conclusion, there is also a clause, my lord, saying that the sale deed will be executed after taking permission. My lord, in that
Dharma Nayak alva?
My lord, that is, my lord, Ratnakar Hegde.
Ratnakar Hegde, sir, yes.
Ratnakar Hegde case. In that case, the agreement was, my lord, on 22/12/2003. There is a condition which says that the sale deed will be executed after permission. My lord, here also case sale deed will be executed after permission.
Yes.
The court says, interprets and says, unless and until possession is given, it will not amount to transfer.
What is the law laid down there?
My lord, the law laid down is,
ವಾಪಸ್ ಕೊಡಕ್ಕೆ ಹೇಳಿದ್ದಾರೆ ದುಡ್ಡು.
the court says, until and unless possession has been handed over, the PTCL Act will not apply anta heltare. That, my lord, however, is in my.
Which paragraph is that?
My lord, appeal for judgment relied on. Now, your lordship may kindly turn to para 9 onwards. Relied on question framed, my lord, is on.
The last para 20 transfer indicate transfer would be only of the government. Come to para 29, sir.
Yes, ma'am.
In other words, parties are liable transfer abide by law and so and so. It cannot be said such a sale agreement would be null and void and required as it required permission of the government. Illu ashte.
Permission and possession irbeku anta heltare. Earlier, namdrallu possession ide. So, my lord, in fact, this judgment will help me also. Now, my lord, if your lordship kindly see paragraph 17 onwards. Paragraph 17. Paragraph 16. In the instant case, since the agreement of sale.
ಎಷ್ಟು ತಗೊಂಡಿದ್ದೀರಾ ನೀವು ಅವಾಗ?
27 lakhs.
27 ಲಕ್ಷ.
Full payment has been made.
ಇಲ್ಲ, full payment ಅಲ್ಲ, agreement ನೋಡಿ.
20 ಲಕ್ಷ.
Now your lordship may kindly.
When we made the payment, and the value of the money was higher than the land. Now ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ my lord. One purchaser, new purchaser has come. He is funding the suit.
Oh, that is why ಇದೆಲ್ಲ.
ಇಲ್ಲ ಅಂದ್ರೆ ಆ ತರ 7th defendant is the new purchaser.
My lord, the agreement.
That is the main issue here.
ಆಯ್ತು.
The suit, my lord, has been filed on 21/10/2023. The agreement is dated 16/6/2014.
So land value is gone 10 times.
The suit, high. I'm just trying to say the date of the suit is 21/10/2023.
Oh, For 7 years after the agreement.
After
Like
the agreement.
9 years after.
After the agreement. And my lord, these are the documents which are produced before your lordships, are the documents which are, my lord, along with the plaint. It is not, my lord, extra documents. I am relying only on the documents which are produced along with the plaint. So, my lord, along with the plaint, they clearly say sale agreement done, permission not taken, possession handed over as per the GPA. In view of that, my lord, I have, my lord, relied on certain judgments which is.
Yes.
But with regard to the contents of the GPA, once again, I am making a submission.
No, GPA, don't worry. We'll go by the
Because
law.
GPL handing over position to the attorney holder anta ellu illa. He is representing the principles.
No, the agreement itself says it would be only after permission.
Agreement says, but GPA says, my
No,
lord,
the
possession
GPA
is
is
consider
a
it.
contract which has been explained by the Supreme Court in its judgment clearly.
My lord,
It is not-
Ramesh Chand.
Even,
Ramesh Chand judgment.
yes, Mila.
my lord, definition of transfer, my lord, 3(1)(e), which includes sale agreement.
Agreement, that is correct. We'll see.
And my
But,
lord, Supreme Court says,
now, in view of the observation made by the division bench of this honorable court on the judgment, what is being relied upon by the opposite is also has to be considered by this honorable court.
Heard result, yes. Interim order idea?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಏನಿಲ್ಲ.
Suit is been.
711 rejected.
11 reject, I have not sought for
Yes,
any.
yes, next. Yes.
These
Yes, Vaibhav.
matters pertain to rehabilitation of the
Correct, what it pertains to, I know. What has happened now?
Pursuant,
Yes, ಎಲ್ಲಿ? ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
that's pursuant to your lordship's order.
Where's Basaraj, sir? Not there?
Basaraj sir is not appearing.
No, he was appearing.
He was appearing for the corporation.
First one ದಿನ ಮಾತ್ರ.
ಇದ್ರಲ್ಲಿ ಇಲ್ವಾ ಯಾವ್ದ್ರಲ್ಲೂ? ಸರಿ.
We have engaged him.
For engage ಮಾಡಿದ್ರು. May I make a request to kindly take the additional
ಈಗ
document?
ಏನ್, what should be done now? Let it come before the regular court?
ಇಲ್ಲ ತಮ್ಮ ಮುಂದೆನೆ ಮಾಡು. ಇವತ್ತೇ ಮಾಡ್ಬಿಡ್ತೀನಿ.
ಇವತ್ತೇ?
ತಮ್ಮ ಮುಂದೆನೆ ಮಾಡ್ತೀನಿ. There are other petitions also which will have to be tagged on.
Yes, my lords.
ಕೊಡಿ, ಅದು ಯಾವ್ದು ಅದರ್ ಪೆಟಿಷನ್ಸ್ ಕೊಡಿ.
The list is here, my lords.
ಲಿಸ್ಟ್
ನಾನು 2 ಸಲ ಕೊಟ್ಟೆ ಅದೇನೋ ಟ್ಯಾಗ್ ಆಗಿಲ್ಲ.
ಆಗತ್ತೆ, ಈಗ ಮಾಡೋಣ.
ಇದರಲ್ಲಿ 93 sanction
93 ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ.
ಕೊಟ್ಟಿದ್ದಾರೆ. My only request is 115 sanction orders ಆಗಿದೆ. 115 ಅಲ್ಲಿ ಕೊಡಬೇಕು ಅಂತ.
ಅಲ್ಲ, ಈಗ ಮಿಕ್ಕಿ 28 ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ?
ಅದಕ್ಕೆ
28 ಅಲ್ಲ,
may I
23.
make a request to kindly take the documents which I have filed, my lords, on 6/6/2025.
ಅಲ್ಲ, is it an admitted fact?
It is an admitted fact.
Yes,
Documents which are filed on 6/6/2025.
115 ಆಗಿದ್ರೆ 93 ಯಾಕೆ ಕೊಟ್ಟಿದ್ದೀರಾ?
My lords, 115 ಅಲ್ಲಿ I have filed an
ಮೈಕ್.
affidavit ಹಾಕಿದ್ದೀನಲ್ವ my lords.
What
ಅದರಲ್ಲಿ I
affidavit?
have produced a document. 28/4 ಗೆ ಹಾಕಿರೋ affidavit.
28/4.
4/25 ಅಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ. ಈ 115 orders ಮೇಲೆ government has conducted an enquiry. CID report ಕೂಡ ತಗೊಂಡು ಟೋಟಲ್ 115 ಆರ್ಡರ್ ಏನಿದೆ ಅದರಲ್ಲಿ 93 ಆದೇಶ ಮಾತ್ರ ಕಾಯಂ ಮಾಡ್ತಾರೆ.
ಯಾರ್? ಗವರ್ಮೆಂಟ್.
ಬೈ ದ ಗವರ್ಮೆಂಟ್. ಆಸ್ ಪರ್ ದ ಗವರ್ಮೆಂಟ್ ಆದೇಶ 93 ರಲ್ಲಿ ಏನಿದ್ದಾರೆ ಆ ಬೆನಿಫಿಷರಿಗೆ ಮಾತ್ರ ಅಮೌಂಟ್ ರಿಲೀಸ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿ ಗವರ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಇಶ್ಯೂಡ್ ಅ ನೋಟಿಸ್ ಟು ಮೀ.
ಸೊ ಈಗ that is released. That 93 is released.
93 is
There was one clause ಅದರಲ್ಲಿ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಪ್ರಕರಣಗಳನ್ನ ವಾಪಸ್ ಪಡ್ಕೊಳ್ಬೇಕು ಅಂತ ಹೇಳಿ ಹಾಕಿದ ಕಾರಣಕ್ಕೆ ನಾವು ಅಮೌಂಟ್ ರಿಲೀಸ್ ಮಾಡಿರ್ಲಿಲ್ಲ. My lords has stated that clause,
Fine.
so
So now
we have
you are
released all the amount.
No, all the amount is
One
not
minute,
released.
wait. Now we wait. Tell me now what is the
Out
problem.
of 10 lakhs, only part of it is released, which is 2 lakhs. Our submissions today would be to release the remaining 8 lakhs.
That is also by the
The
government
government
my
order,
lords.
initial government orders in the year 2018 was for a sum of rupees 5 lakh, 10 lakhs.
10 lakhs.
There was a direction issued by this honorable court in writ petition, if my lords were to kindly take one writ petition 15614 of 2023.
ಏನ್ ಹೇಳಿ?
Adರಲ್ಲಿ coordinate bench had directed them to implement this government order, pay 10 lakhs at a speed, very speed first. To circumvent this order, they modified the government orders for initially for 1 lakh and subsequently for 2 lakhs. And restricted the government orders from 115 to 1993.
That is what is questioned.
That is what is questioned, my lords. When the government, the coordinate bench passed this order, my lords, there was no such restrictions. either for 93 or for 10 lakhs. To circumvent, that is the reason why, my lords, any writ petition, my lords, if my lords were to kindly take 15614 of 2023, my
ಮತ್ತೆ
lords,
ಇದು ಈಗಲೇ ತೀರ್ಮಾನ ಎಲ್ಲಿ ಮಾಡಕ್ಕಾಗತ್ತೆ?
ತೀರ್ಮಾನ ಅಲ್ಲ,
ಮತ್ತೆ?
ನಾನ್ ಕೇಳ್ತಿರೋದು ಈಗ 93 ಗೆ 2 ಲಕ್ಷ
No, if the
ಕೊಟ್ಟಿದ್ದಾರೆ.
government order is in question, we'll have to hear the state.
My only request is notes 93 government orders ಗೆ ಈಗ ಏನು 2 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ, 115 government orders ನಗೂ 2 ಲಕ್ಷ ಈಗ immediate implement ಮಾಡಿ, subsequently we will argue the merits. We are not shying away from arguing.
No, ಈಗ 93 were undisputed. So
93 were
93 ಗೆ ಕೊಟ್ಟಾಗಿದೆ ಈಗ. ಅದು 1 lakh each,
2 lakhs each.
2 lakhs ಕೊಟ್ಟಾಗಿದೆ.
ಕೊಟ್ಟಿದೆ.
All right.
ಈ
ಈಗ ನಾವು
115 ಗೆ if my lords
ಈಗ total how many of you are there?
Milods,
Yes, 2000 ballots.
2000 members. In all the writ petitions, Milods.
Milods.
That is the reason, Milods, my only request to kindly take the documents which I have filed it on 6/6/2025 in the open court. Memo for production of
ಇದೆ ಇಲ್ಲಿದೆ,
documents.
yes, ಹೇಳಿ.
If my lords were to kindly take, Milods,
That direction has become final? Coordinate bench ಅನ್ನು direct ಮಾಡಿದ್ರಲ್ಲ.
that has not been, to circumvent that direction, Milods, this present petition. If my lords were to kindly take, Milods,
One more.
76, 70,
One moment, madam.
74, Milods, page number 74 in that. Production of document. Sir, ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ಬಿಡಿ, ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೇವೆ. Yes, full list ಕೊಟ್ಟಿದ್ದೀವಿ.
ಇಷ್ಟೇ ನಾವು ಉಳಿದಿರೋದು?
Yes.
ಅಷ್ಟು ಉಳಿದಿದೆ.
We'll fix a date, 7th or 14th. ಯಾವತ್ತು? 7th, 14th?
ಇದೊಂದೇ ರಿಕ್ವೆಸ್ಟ್.
ಈಗ 2 ಲಕ್ಷ, ಈಗ 93 ಗೆ ಬಂದಿದೆ ಬರ್ಲಿ, ಮಿಕ್ಕಿದ್ದ will decide and close it.
ಅಲ್ಲಿ ಅವ್ರು ಏನಕ್ಕೆ 115 ಅಲ್ಲ ಅಂತ ಹೇಳಿ ಅವರೇ ರೆಕಮೆಂಡೇಶನ್ಸ್. ಇಫ್ ಮೈ ಲಾಟ್ಸ್ ಟು ಕೈಂಡ್ಲಿ
Your recommendation ಹೌದು, but the government has said.
ಕೈಂಡ್ಲಿ ಸಿ ಪೇಜ್ ನಂಬರ್ 74. ಅವ್ರ ರೀಸನಿಂಗ್ಸ್ ನಾನು ತೋರಿಸ್ತೀನಿ. ಈ ಪೇಜ್ ನಂಬರ್ 75 ಮೇ 2017-18 ಸಾಲಿನ
ಅಲ್ಲದೆ ನಿಗಮದಲ್ಲಿ ಲಭ್ಯವಿರುವ
115 ಮಂಜೂರಾತಿ ಆದೇಶಗಳಲ್ಲಿ ಕೆಳಗಡೆ ಫಸ್ಟ್ ಲೈನ್ 115 ಅಲ್ಲಿ ಅವರೇ ಹೇಳ್ತಾರ ಸಮ್. If my lords were to kindly take page number 76 again. Plus, what are the government orders which are there, which are right to information which they have issued? There are 115 government orders. If my lords were to kindly take not one or two documents, my lords, where I will have to I'll substantiate there are 115 government orders. And reason why they are refused, my lords, may pass on the one, I'll pass on, my lords, the office copy of my. ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ, ಒಂದು ಗವರ್ಮೆಂಟ್ ಸಭೆ ನಡೆದಿದೆ, ಅದರಿಂದ ನಿಮ್ದು ಯಾವ್ದು ಬರಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಅವ್ರ ಎಂಡಾರ್ಸ್ಮೆಂಟ್.
ಆಯ್ತು, ವಿಲ್ ಕನ್ಸಿಡರ್ ಆಲ್ ದಟ್. ಈಗ ಅರ್ಜೆಂಟ್ ಅಲ್ಲಿ ತೀರ್ಮಾನ ಮಾಡಕ್ಕಾಗಲ್ಲ.
115 ಜನಕ್ಕೆ 115 ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ಸ್, ದೇ ಆರ್ ವರ್ಚುವಲಿ ದೇ ಆರ್ ನಥಿಂಗ್, my lords. ಅದಕ್ಕೋಸ್ಕರ we are
ಈಗ 93 ಕೊಟ್ಟಾಗಿದೆ.
93
ಇನ್ನು ಮಿಕ್ಕಿದ್ದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ we will do it.
ಎಲ್ಲ 93 ಅಲ್ಲೇನೆ ಒಂದು ಡಬಲ್ ಪಿಟಿಷನ್ ಇದೆ. ಈಗ 115ರಲ್ಲಿ ಇನ್ನು ಎಷ್ಟು ಸಾವಿರ ಜನ ಇದಾರೋ ಗೊತ್ತಿಲ್ಲ, ಮೆಲೋಡ್ಸ್. ಅದ್ರಲ್ಲಿ ಬೇರೆ 7 ಪಿಟಿಷನ್ ಆಫ್ಟರ್ ಮೆಲೋಡ್ಸ್ ಹ್ಯಾಸ್ ಸ್ಟೇಡ್ ದ ಕ್ಲಾಸ್, ಮತ್ತೆ 7 ಪಿಟಿಷನ್ ಹೊಸದಾಗಿ ಹಾಕ್ಯಾರೆ. ಹಿಂಗೆ ಏನಾದ್ರೂ ಈಗ 115 ಆರ್ಡರ್ಗೆ ಅಲೋ ಮಾಡಿಬಿಟ್ರೆ
no, that if they are entitled, they are entitled. It's not that merely because petitions are coming before the court.
It is true, we have admitted 115 order ಇದೆ ಅಂತ.
That is not the way to bring down pendency.
Yes. Within 93 government
stopping litigation is
when within 93 government orders, what I have heard is adralu keloru who have not approached this court, they have made a representation which has been refused by the corporation within 93 government orders.
No, Melods.
Court ge
barbaadu information is.
Yes, tag these petitions along with so and so, list them all on 7th.
Melods, that copy has not.
What copy?
ಹೊಸ ಪಿಟಿಷನ್.
I'll serve it to them.
Serve everything, yes. ಯಾವುದು ಹೊಸದು ಯಾವುದು ಇದೆ ಇದರಲ್ಲಿ?
Filed about 13 new petitions.
13, Melods. 7 they said.
Where are they?
A list.
I had actually the orders were passed to tag those matters with these matters.
All right. Tag these petitions along with so and so, list on 7th. Yes.
Melods, even for the governments, they were not.
ಕಾಪಿ ಕೊಡ್ತಾರೆ.
ಸರ್ಕಾರ ಕಾಪಿ ಸರ್ ಮಾಡಿದ್ಮೇಲೆ ಫೈಲ್ ಮಾಡಕ್ ನಮ್ಗೆ ಅಧಿಕಾರ ಇರುತ್ತೆ.
ಇವೇನ್ ನೋಡ್ರಲ್ಲ ಬಿಡಿ, ಅವು ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ನೋಡಿದ್ರೆ. Yes.
7th at 2:30.
7th. November
30 minutes or
230.
13,
So there is a matter relating to the forest where the land was granted to the petitioners.
The 4 ಎಕರೆದಾ?
4 acre.
ರೆಗ್ಯುಲರ್ ಕೋರ್ಟಲ್ಲಿ ಬರಲಿ.
There is already an order feature, your lordships are passed.
ಯಾರು ಮಾಡಿದ್ರ ಆರ್ಡರ್ ಮೇಲೆ?
Your lordship may kindly see the order, my lord, which is passed on 5/3/2025.
Yes.
Court says, my lord, give alternative land. And my lord, they filed an affidavit saying that principal secretary has directed me not to give.
ತಹಶೀಲ್ದಾರ್ ಕರೆದು ಗಲಾಟೆ ಮಾಡಿದ್ರು ಅದೇ ತಾನೇ?
ಅದು ಬೇರೆ case.
ಅದ್ಯಾವುದು?
That is different.
ಅದು
Here,
ಬೇರೆ.
here, my lord, the petitioner number 1 is a doctor, petitioner number 2 is a young member of this bar who's here. His grandfather, my lord, had taken part in the, that is the order, my lord.
ಇವತ್ತು ನಿಮ್ದೆಲ್ಲ ಅಜೆಂಡಾ ಅದೇನಾ?
That is the order, my lord. Which
ಅಲ್ಲ, ಟೇಕನ್ ಪಾರ್ಟ್ ವಾರ್.
My lord, therefore they had granted 4 acres.
ಬೆಳಗ್ಗೆನೂ ಅದೇ ಹೇಳಿದ್ರಿ ಅಲ್ಲಿ.
My friend's grandfather, my lord, was taken part in the war. Then 4 acres was granted. And Podi has been done.
ಐಡೆಂಟಿಫೈ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತಿರೋದು ಇದೇನಾ?
Illa, Podi has been done, identified. We are in possession of the property.
Then what?
Then the forest department comes after 30 years and says 2 acres of the property belongs to the forest.
Oh, yes. Then
No,
they
my lord,
said they
this-
will identify different.
This honorable court directed a survey to be conducted. Survey ಮಾಡಿ 2 acres, yes, it's a forest ಅಂತ ಹೇಳಿದ್ದಾರೆ. Therefore, your lordships, the coordinate bench, my lord, directed an alternative land to be given. Or the deputy commissioner to be present.
Where is the state?
The affidavit is filed by the state now. Your lordship may kindly see.
ಒಬ್ಬೊಬ್ಬರೇ ಬರ್ತಾ ಇದ್ರೆ ಆಗಲ್ಲ. ಇದಕ್ಕೆ ಯಾರಿದ್ರು ಮುಂಚೆ? ಅದೇ ಬೇರೆಯವರು ಯಾರು? ಜಾಫರ್ ಇದ್ದಿದ್ದ?
ಇಲ್ಲ, Mr. Banu Prakash, additional advocate.
Banu Prakash had come. Ask him to come. Passor. Yes.
fourteen,
CBI.
Yes, CID, reinvestigation to CID. Filing the detailed synopsis of
ನೋಡಿ. ಯಾವುದು? You are the complainant.
Yes, Your
Complainant
Lordship.
to accused.
Complainant-
R225 ಯಾರು?
R225 are the initial accused against whom the first crime was registered. They were the accused then when the case was registered. Later on, the very complainant was made an accused in this case,
Correct.
dropping.
Who are
those-
these now?
Now, these are the neighbors of the deceased, Your Lordship, who picked up the fight, assaulted the deceased.
ಅದು synopsis ಅಲ್ಲಿ. ತಗೊಳ್ಳಿ ಮೇಡಮ್. We'll post it on 7th. The dictating ಹಾಕಿತ್ತಾ?
Dictating.
7th will do it. Yes. Just on 7th.
Ajay.
ಅವ್ರು accused ಅವ್ರಿಗೇನು ಬೇಡ ಮೇಡಮ್. Yes, next.
15.
I appear for the petitioner's counsel. The land, my lord, was a civic amenity site. In fact, my lord, we have placed before your lordship.
I think I asked for the records.
Records.
ಇಲ್ವಾ?
ಅಲ್ಲ, ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು, ನಾವಲ್ಲ.
ಅಲ್ಲ ಅವರು
BDA.
BDAಗೆ.
Which matter?
ನೀವು ಹೇಳಿ ಸರ್.
Civic amenity site anna, they have, my lord, allotted it for a commercial purpose. That is what, my lord, we are assailing. In fact, my lord, we have placed certain materials which show that, my lord, originally, my lord, it belonged to the Maharaja who, my lord, gave it to Vishwarama hotels. They, my lord, formed a layout. Part of it, my lord, was a civic amenity site. And, my lord, the BDA now, my lord, has allotted it to them for commercial purpose and says it's a commercial site. We have produced, my lord, annexure M in the rejoinder.
Yes.
Aditya probably must have, my lord, said.
ಅಲ್ಲ ಯಾವ ನಾನು I said get the records, I remember.
Since year number 15. The allegation is that there is no plan. Plan is there.
What is the connected matter? ತಾವು ಯಾವ್ದ್ರಲ್ಲಿ appear ಆಗ್ತೀರಿ?
He's appearing 15.1.
Residents Welfare Association.
Our 15.1. I'm appearing for BDA 15.1.
You're appearing for BDA.
BDA.
15, which is, what is 15? Civic amenity site. Sorry, yes.
Sanction plan kottidarante. Sanction plan is not relevant. What is relevant is whether, my lord, it is a civic community site. If it is, my lord, then it can't be given, my lord, for commercial purpose. This is a short question.
All right, ನೀವು ಹೇಳಿ ಯಾವ್ದ್ರಲ್ಲಿ ಅಪ್ಪ ಆಗ್ತಿದ್ರೆ submission ಮಾಡ್ಬಿಡಿ sir.
Please come to, my lord, page 11 of my rejoinder.
Yes, 15.1.
Correct. WP, my lord, 33555 of 2024.
If it is a civic amenity site, you will have to explain how you have granted it.
Simple point. There was a complex for more than 25, 30 years. The very same property in question, which was demolished and being reconstructed all over again. Only difference is, Malad, is being in a public and private partnership, it is being done. So therefore, Malad, the fact that it existed for more than 30 years is not in dispute. It's only demolition and reconstruction.
Well said. Yes, yes, sir.
And there may be one more point. In a
So
civic
let him-
community
let's,
site, you can put up a market.
Let the
Yes, yes.
senior counsel finish.
Yes, yes.
Yes, sir.
Please come to, my lord, page 11 of the rejoinder.
11 of the rejoinder. Yes, sir.
This is, my lord, the approved layout plan. And my lords may be pleased to see, my lord, it has been approved by the town planning member of, my lord, the VDA, all of them, in 77. And, my lord, this is a civic amenity site. My lords get at that, my lord, serial number 6. Road ಆದ್ಮೇಲೆ
Rejoinder.
sorry.
15.1.
ಇದೆಂತದ್ದು ಇದು? ಎಲ್ಲಿದೆ ಅದು?
Yes, sir. Page?
My lord, page 11.
Oh, the plan.
Yes, my lord.
Yes.
Layout plan approved by the BDA.
1977.
Correct.
Yes.
My lord sees, my lord, at the corner 6 ಅಂತ ಬರುತ್ತೆ. That is, my lord, after the Bellary road ಆದ್ಮೇಲೆ ಇನ್ನೊಂದು proposed nice, my lord, 40 feet wide road ಅಂತ ಬರುತ್ತೆ. ಅದರಲ್ಲಿ serial number 6, my lord. That is, my lord, a civic amenity site. What they have done is, now, my lord, they have given it to, my lord, the respondent for, my lord, a commercial purpose.
Yes.
And plan was not there. This, my lord, was, according to them, my lord, allotted in the year, my lord,
77.
Correct. 77 ಅಲ್ಲಲ್ಲ. 2016, ಅಲ್ಲಿಂದ ಏನೂ ಮಾಡ್ಲಿಲ್ಲ. Then, my lord, they started construction. When we said that, there is no plan ಅಂತಂದಾಗ, ಈಗ ನಾವು plan ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂತ ಅದನ್ನ ಅವ್ರಿಗೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
Yes.
My submission to your lordships is, if it is a civic amenity site, it can't be given, my lord, for commercial purpose. It's a short question, my lord, for my lord's consideration.
So
We
according
have
to the
also
plan,
filed an application.
according to the plan, it is a civic amenity.
Civic community site. And, my lord, we have also filed an application. When we asked for, my lord, under the RTI for a copy, they did not furnish to us. We, my lord, have now filed an application for your lordships, IN number 2, for, my lord, a direction to the BDA, my lord, to produce it.
Yes. So that's the only ground. It's a
That's,
civic
my lord, the
amenity.
main ground. Secondly, my lord, without plan, my lord, he started. Now, my lord, they backdate the thing. That's, my lord, our contention.
Now, two things they'll have to answer.
Yes.
Civic amenity site is one thing.
Correct.
And without plan, construction is being done.
Yes.
Those are the two submissions?
Correct. And, my lord, if it is a civic amenity site, it could not have been, my lord, given to them, my lord, for construction of a commercial purpose.
Oh, that is there.
That's
Yes.
Secondly, my lord, the entire area, my lord, the earlier, my lord, my learned friend very rightly said, there were, my lord, small shops for, my lord, the residents' usage. Ultimately, my lord, a civic amenity site. Now, my lord, he is constructing an office. If it is a this thing in the civic amenity site, there can't be an office. It has to be, my lord, for something which benefits the residents. This is in Sadashiv Nagar. Therefore,
yes,
this is a short question for my lord's consideration. Of course, we have, my lord, there was an interim order. Notwithstanding that, my lord, your lordships, my lords, modified the order, saying that, my lord, they had gone deep. So, my lord, your lordships directed that, they'll only, my lord, put the shoring. That's, my lord, in spite of it, they, my lord, have put up, my lord, foundation also. Then we filed one application for contempt. That is, of course,
Yes,
pending.
yes.
That's all right, my lord. That
That
is
will
incidental. Probably, my lord, a prejudicial argument, if I can say that.
Yes, sir. These are the two AG. ಅವ್ರದ್ದಾಗಿದೆ.
He lives right across on the same road.
ಇಲ್ಲ ನಾನಿಲ್ಲ ನಾನು ಸ್ವಲ್ಪ ಕೆಳಗಡೆ.
ಸ್ವಲ್ಪ ಕೆಳಗಡೆ ಇದೆ. Admittedly, Maharaj, the Sadashnagar commercial complex was there for more than 30 years. The question is, Maharaj, if that is only that particular land is thought to be developed now, as by issuing a tender and doing a commercial activity, mainly for the residents of that particular area, Maharaj, the undisputed fact that the ground floor and that area is being used for various shops and things like that. The only difference is now, Maharaj, under public and private participation, it is being rebuilt, giving under pursuant a tender. Tender is not challenged. Everything has become final in that regard, Maharaj. Construction has started. This is in the year 2024, Maharaj, which has been given. Now, recently, after everything is done, the present petition is filed after nearly 6.5 years in 2024, Maharaj.
2016 ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋದಲ್ಲ.
Please, Maharaj, the Lordship may kindly see, Maharaj, the petition is filed in 2024. The concession agreement was signed on 22nd March 2018, Maharaj. Pursuant to which, Maharaj, the project has commenced. The petition is filed in 2024, Maharaj. So what the plan which is thought to be relied upon is not the correct plan, because that is a private layout plan. Insofar as the CDP as on today also shows the land to be a commercial thing. The BDS produced it, Maharaj.
The revised master plan designates this area as commercial.
RMP,
It's there in the objection statement.
Statement of objection which was filed on 2nd February 2024 is the RL 15.1.
I'm holding 15.1 on.
Yes.
That is on second.
Page 13. In the objection statement, we have filed.
ಅದು 15.1. Oh, correct.
ನೀವು ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ ಓದಕ್ಕೆ ಆಗಲ್ಲ.
ಇಲ್ಲ ಅದಲ್ಲ ಸರ್, ನೆಕ್ಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್
ನೋಡಿ, ನೆಕ್ಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಕೊಡಿ. ಸ್ವಲ್ಪ ಕಲರ್ ಎಲ್ಲ ಕೊಡ್ರಿ ನಮಗೂನು. ಬರೀ ನೀವೇ ಕಲರ್ ಇಟ್ಕೊಂಡ್ರೆ ಹೇಗೆ?
Someone has to.
Yes, sir.
If you got this page 13, that's the revised master plan.
ಏನ್ ಕಾಣ?
Portion.
The blue portion which is marked.
ಎಲ್ಲ ಬ್ಲೂನೇ ಇದೆ.
ಅಲ್ಲ, ಅದಲ್ಲ. Next doc. Next part. That is, I'll show you lots of that as well. There is
R2.
My lord will see that blue.
Statement of objection.
Here, this one. That's commercial. That's the same site. In the revised master plan, it is designated as a commercial site.
What's this red circle?
That we put to identify.
So therefore, the whole case which revolves around the point that commercial activity cannot come on this plot.
So this is the RMP.
RMP. So the land use.
2015.
Blue is commercial.
Blue is commercial. Blue is commercial.
And one of the important, it was a commercial complex, Maharaj. So therefore to say, and what was commercial, as per the CDP, again a commercial complex is coming up. The fact is, Maharaj, an agreement was signed way back in the year 18. 22nd March 2018. After 6.5 years, when the project is being built, in middle of the construction, Maharaj, they sought an interim order and obtained.
No, there is an interim order.
There is an interim order. That's why, Maharaj, the urgency in them. So therefore, the short point, commercial activity cannot go on in this plot, and on the assumption that it is a civic amenity, not a commercial plot, to stand to fail.
And your lordship may also see, just to answer my learned senior friend's argument, section 2BB of the BDA Act, which defines the civic amenity as also a market. Therefore, construction of a market, and market does not mean a vegetable market. It can be more than a market. A market has a meaning as we understand it. It could be a market which involves shops and which has always been there in that place. It is just a redevelopment of that area. That's the only reason. And this petition note is obviously at the hands of some persons who are inimical to having it there. But ultimately, at the end of the day, in my respectful submission.
Anyway, I'm not there, Bullard. I can tell you, Lordship, I'm 200 meters away.
No. I wanted to point out there was a commercial complex. You'll have only one thing, it would be a better complex than what was there.
That's all right.
10 lakhs is also.
Please come to my lord.
Yes.
In fact, my lords may look at my lord page 30 of the petition.
Yes.
It is my lord of the year 2018. I ask myself this question. When was the plan granted? When did they start construction? Not a whisper.
Where is the plan sanction?
On 26/9/2023. And they started, my lord, the construction. Please come to my lord. We have filed, my lord, a memo dated. ಎಷ್ಟು ಮೆಮೊಗಳಾಗ್ತದೆ ಒಂದೆಲ್ಲ ಕನ್ವೀನಿಯನ್ಸ್ ಕಂಪ್ಯೂಟೇಷನ್ 16/10/2025.
I'll see.
Sorry, my lord.
Plan sanction ಆಗಿರೋದು ಯಾವತ್ತು?
Plan sanction
ಅಜಯ್ ಕುಮಾರ್
ಯಾವತ್ತಾಗಿದೆ ನೋಡಿ.
Must be in 2024.
When did the construction commence?
13/12/2023. I'm sorry, ma'am. 13/12/2023.
Plan sanction?
Please, ma'am.
Only after that. And then they filed a writ petition. Then it is stopped. So, my lord, after that, there's no.
So for the last 1 year it is stopped, is it?
Yes, my lord.
Construction is stopped.
Construction is stopped. As a matter of fact, what happened was, they had already excavated. And since the excavation had been done, there was a danger to other buildings nearby. Therefore, we were permitted to shore it up and to put up a retaining wall. That permission has been granted. That has been done. They are saying, no, we've done much more than that. That cannot be true, which is why they filed a contempt.
Anyway, construction is stopped at that.
Construction stopped.
Compliance of your lordship's order.
Construction stopped.
Yes.
My submission, my lord, by way of reply is, my lord, threefold. One is, my lord, if it is a civic amenity site, merely because, my lord, master plan, my lord, shows it as commercial, my lord, can't change. This is one aspect, my lord, which your lordships will bear in mind. Secondly, my lord, please come to, my lord, page 385 at 386. We filed an application to the RTI.
Plan.
Howdo? Nothing was given to us. That's why, my lord, when we filed it, yes.
ಈ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಜಯ್ ಕುಮಾರ್
ನಮಗೆ ಈಗಲೂ ಕೊಟ್ಟಿಲ್ಲ, ಅವ್ರಿಗೆ ಯಾರಿಗೂ ಕೊಟ್ಟಿದ್ದಾರೆ. ನಾವು 15.1 ಅಲ್ಲಿ ಅದು ಕೊಟ್ಟಿಲ್ಲ.
Point to answer. We did not reply. The 77 plan.
ಮುಂಚೆನೆ ಕಾಪಿ ಕೊಡಕ್ಕೆ ನಿಮ್ಗೆ. Yes.
It should have given one submission to which was argued. The 77 plan is not the layout plan of RMB extension. It is a private layout plan that cannot be relied upon. In our plan, which is approved, it doesn't show as the civic amenity. That has been produced as annexure.
That very large blue plan.
R1.
That does not show it as a.
That's what he says.
That is for the entire RMB extension.
My lord, I asked myself, then in that event, page 19, your lordship saw of the rejoinder.
Yes.
This is, my lord, issued by the BDA.
Yes, yes.
Then, my lord, I asked myself, are they denying this? Then, my lord, they should have filed some affidavit before your lordships. Not a whisper. It can't be that, my lord, orally now they say that, my lord, it is.
Yes, sir.
I would submit, my lord, even at the very worst, if you also take it as civic amenity, section 2BB.
Market.
This is a market.
My lord, they are not constructing a market. Let them, my lord, point out that they are constructing a market.
The market.
Plan.
The market does not mean a fish.
Office, my lord, is a market.
Market ಅಲ್ಲ ಹೇಳಿದ್ದು.
The market is a market. It can be, my lord, a nicely developed shopping complex is also a market.
No, sir is telling about office spaces.
Office space also.
Market.
No. If dominantly it is a market, it's fine.
No, office space also is a market.
It's also in a way a market.
If that interpretation is given to 2BB.
No, I'm not saying that. I'm saying a shopping complex, my lord, ultimately is a market. That there can never be a dispute.
If it's a shopping complex, yes.
Shopping complex.
But if it's office complex, no.
No, it's not an office complex. It is a shopping complex.
My lord, please have a look at the plan, my lord.
Commercial shopping complex. Plan.
And if your lordship look at, my lord, what the plan they have given, it is dated 24/4/2025.
Where is this sanction? Construction has started on 30/12/23.
Date illegal implementation plan 24/4.
So
Sanction is subject to decision of this honorable court, my lord, in WP number 33555 of 2020.
So after the filing of the petition, you have sanctioned the plan.
11/3/2025, my lord. Petition was earlier.
Huh?
The work order and all was earlier.
Therefore, my lord, cat is now out of the bag. That's all that I can say.
Yes, let me see. 2BB will consider. Reserved.
Filed an impleading application, Lords.
Tender? Subramanya ಅವರು ಯಾರಿಗೆ?
Lords, I have in 15.1, Lords, I have filed an application seeking, Lords, to come on record. Because, Lords,
Who are
I am
you?
the special purpose vehicle which is constituted, Lords, pursuant to the concession agreement entered into.
No, no, whether the entry of that vehicle is necessary or not, we'll see.
Lords, this is a case where, Lords, as pointed out, Lords, that earlier commercial complex was there. Thereafter, Lords, they have demolished it, and Lords, now it is sought to be redeveloped. Lords, my Lords may kindly consider, Lords, this particular fact, Lords, that even in a residential area, Lords, even if the site, Lords, is belonging to purely residential, Lords, use, then also, Lords, under the revised master plan 2015, Lords, to some extent, Lords, even the commercial activity is permitted. That is, Lords, to the extent of 20% of the siteal area. Lords, similarly, Lords, this particular plot, Lords, which is Lords, an area which was earlier, Lords, the commercial complex was built by the BDA and it was in use, Lords, till we could demolish, Lords, the building in the last, Lords, year. But till such time, Lords, it was being used by, Lords, the people, Lords, in the locality. Lords, now what is sought to be done, Lords, is only redeveloping of, Lords, the commercial complex by replacing, Lords, the newly built commercial complex, which will accommodate, Lords, the earlier tenants also. Lords, under these circumstances, Lords,
1 minute, sir. Yes, sir.
ಇಲ್ಲ ಅವ್ರು ಮಾಡ್ಲಿ ಅವ್ರು ಮುಗಿಸಿ ನಾನು ಒಂದೇ ಒಂದು ಎರಡೇ ನಿಮಿಷ ಹೇಳ್ಬಿಟ್ಟು
A special purpose vehicle.
My submission to your lordship is, my lord, what was there was not a commercial complex. There were small shops, my lord, catering to the, my lord, the resident locality, my lord, civic community site. Now, my lord, what there is, my lord, please come to, my lord, page 379. Notice to proceed. Yavaga 2024 ಅಲ್ಲಿ, and my learned friend, my lord, the advocate general has been briefed. He has been briefed to say ನಾವು 16 ಶುರು ಮಾಡಿದೀವಿ ಅಂತ ನೋಡಿ ಅಲ್ಲಿ. Proceed, my lord, ಆಗೋದಕ್ಕೆ 2024 and plan is sanctioned, my lord, in 2025.
25.
ಇದು ನೋಡಿ ಇಲ್ಲಿ page
ಇಲ್ಲ delay and latches ಇಲ್ಲ. Concession agreement. But when did the process begin?
ನಮಗೆ ಏನು ಗೊತ್ತಿಲ್ಲ ಎಲ್ಲ everything was secret and it came in the paper, then, my lord, we started protesting.
2018 itself it had come in the paper, we can face it. Subsequent 23-24 is the implementation of the project. What was envisaged is was in the 2018, what is to be done under the concession agreement. What is under the agreement is thought to be implemented.
Lord, that we've explained in our objection statement. The concession was granted earlier. And
You
thereafter,
consider.
Lord,
It is only the implementation of the concession agreement of 2018.
Heard reserved. What is the other petition about? Same challenge?
Same, my
And
lord.
senior is already made.
Please, my lord.
Great. Next. Interim order subsisting will continue to the disposal of the petition.
one more submission, Lords, is that right now,
yes,
Lords,
sorry,
I have
sir.
spent nearly 4 crores, Lords. Nearly 4 crores, Lords, on pursuant to. Lords, these are all the issues, Lords, which certainly, Lords.
I have got the photograph and I, my lord, passed through that, except, my lord, an excavation.
Nothing is 4 crores for excavation.
No, not for excavation alone, Lords. The concrete retaining wall is built, Lords, by also supporting, Lords, the
We'll
construction of the
consider it
columns.
legally. Yes, next.
Please.
16.
My lords, quick 16 minutes. Quick background, my lords, before your lordship looks at
16, I want some time.
Because I'll finish my bit, my lords. Then, of course, they can respond.
Yes. No, since he's
I'm
here.
here. Then Supreme Court starts from Monday. My lords, I'll be very brief, my lords, on the facts. And I'll not trouble your lordships with more than 2 or 3 papers. Your lordships permit me, please don't see the papers, my lords. I'll place the facts in the nutshell. I am, my lords, an energy company which, my lords, trades in electricity. There was a transaction by which, when Karnataka needed power, power was imported from Maharashtra to Karnataka through a radial line which, my lords, connected Telangana in Maharashtra to Chikkodi. Now that radial line is, my lords, a line which actually transports power one way and not 2 ways. And therefore power was imported from Maharashtra into Karnataka. And there was an agreement between me and Bescom. Bescom needed the power, where Bescom would pay me 4 rupees 83 paisa per unit of power. The power flowed, there is no dispute. For the power that has been supplied, Bescom had to pay me, there is no dispute. There is a power purchase agreement and an amendment to the power purchase agreement in terms of a supplemental power purchase agreement. But in a transaction, my lords, when power moves from one state to another state, there is something called unscheduled interchange which occurs. That is, India is today one grid. Therefore, if I agree that I will take 200 units of power from Maharashtra into Karnataka, I, BESCOM, should remain at 200 units. If BESCOM takes 220 units, that 20 units is not being given by the supplier. That is, I'm not giving it. Maharashtra must give the 20 units from somewhere because there is power consumption here. And that 20 units becomes the unscheduled overdrawal. Similarly, my lords, if BESCOM does not take the 100 units, but takes only 80 units, there will be a 20 unit excess, there will be a 20 unit underdrawal by BESCOM. The agreement said that for any unintentional overdrawal that BESCOM would do, of whichever that unit is, the same quantum of money per unit, which is 4 rupees 83 paisa, would be paid to me because I had to intern under something called a final balancing settlement mechanism, which is, my lords, a regulation both by KERC and by MERC for Maharashtra. The Maharashtra final balancing settlement mechanism would impose a levy on me because there is more power which has gone on. I have to pay Maharashtra, BESCOM would pay me. A dispute, my lords, arose, and that dispute is not germane here, but a dispute arose with Maharashtra saying for unintentional overdrawal, it's not 4 rupees 83 paisa, you have to give me 12 rupees. I contested that, my lords, as Global Energy, I contested that, my lords, before the Maharashtra Commission, saying 4 rupees 83 paisa I will give, but 12 I cannot give. The Maharashtra Commission held against me and said, no, you will pay under a standby agreement 12 rupees and not 4 rupees 83 paisa. I went up in appeal, my lords, before the Appellate Tribunal of Electricity. Maharashtra put a gun to my head. I withdrew the appeal. Fortunately for me, when I withdrew the appeal, PCKL and BESCOM, that is the power company of Karnataka, which was, my lords, the procurer, they, my lords, intervened and contested that appeal saying 4 rupees 83 paisa is to be paid, but 12 rupees is not to be paid. Today, I stand before your lordships only for that 4 rupees 83 paisa.
And now they are doing a volte-face?
No, let's, I'll tell you, before the volte-face, what they did. If it was just a volte-face, I couldn't have filed a writ, my lords. I, my lords, petitioned them saying, please pay me for the power that you have consumed. You have in turn taken the power and given it to consumers in Bangalore. They have paid you their bills. Money is with BESCOM. Why is it you are not giving it to me? Because I'm the supplier of power. They say we will go to the learned advocate general. Not my dear friend Shashi, my lords, the predecessor. Fortunately, I file an RTI, I get that opinion. The learned AG issues an opinion, my lords, to PCKL, specifically indicating that 4 rupees 83 paisa you should pay. Rest, that is anything more than 4 rupees 83 paisa, please wait for whatever dispute that is emanating in APTEL. My lord, that's only a legal opinion. I cannot, my lords, put my fulcrum on that legal opinion. But fortunately for me, that legal opinion was before the board. And today, my lords, BESCOM is not a state department. It is a separate company as an instrumentality. The board, my lords, passes a resolution admitting the liability of 4 rupees 83 paisa and specifically saying 4 rupees 83 paisa could be paid to you, Mr. Puvaya. However, final settlement, which is, my lords, the 12 rupees, 4 rupees difference, that final settlement will happen after the litigation is over.
Now 483, who's stopping you from getting 483?
My lords, I demand they don't pay. Therefore, I file a writ petition, my lords, that they have a contractual liability. Your lordships have held, ABL International has held, and MP Power Corporation in 2024, in the context of electricity, has held that discoms cannot just vanish by indicating that it's a contractual dispute. They are an instrumentality of state. Contract is 4 rupees 82 paise. Power consumed is admitted. And my lords, a board resolution is passed.
That is ABL para 28 is.
Please, my lords. And based on ABL, my lords, the Supreme Court in 2024 in MP Power indicates that liability should be paid. My lords, in fact, it is not the case that I am now pocketing this money. I have paid the 4 rupees 82 paisa to Maharashtra already. Maharashtra is claiming 12 rupees from me, for which a litigation is going on. Now, at least the 482.
Now you are entitled to 483.
That's all. My claim, my lords, is it's about 48 crores, my lords, at 4 rupees 82 paisa. My lords, in that light, please see, my lords, 4 or 5 clauses of the agreement, and I'll not trouble your lordships any further. My lords, the power purchase agreement, my lords, your lordships will find, and my lords, just in terms of completeness, please come to page number 157. The genesis of this was not a green room transaction, my lords, sitting in somebody's chamber and signing a contract. It was a tender. And in the tender, the condition is that we will have an agreement and standby power will be paid. Please see at 157, my lords. Yes. This is the RFP in the tender document. My lords, at 157, please come to item number 6. Kindly see on top, my lords, on 157. Pre-requirements, permits and clearances to be obtained by the successful bidder. I am the successful bidder. Please see 6. Standby agreement for generator with MSC DCL is the Maharashtra State Electricity Development Company Limited. That is, I think, Distribution Company Limited. Agreement between successful bidder and MSC DCL, and whose responsibility? Kindly see my responsibility. But it's pursuant to this that I enter into a standby power agreement which says 12 rupees. Now please come to the PPA, my lords, at page number 221. Please see at 221, middle quadrant of the page, 4.2.3, my lords, scheduling and dispatch. This is the agreement between me and my esteemed friend Mr. Chinnappa's client Bescom. My lords, it starts earlier. Please come to 221. Please see Article 4, capacity, availability and dispatch.
Yes.
Please may I invite my lords' kind attention to 4.2.3.
While
Variation between scheduled energy, that is at 100 units,
and
actual energy, which I take as 120 units, at the delivery point shall be accounted through the UI's unscheduled interchange as for the provisions of the grid code and the UI regulations issued from time to time. Please see the next one, my lords. For any overdrawal by the procurer, that's Bescom, at the delivery point, applicable UI charges payable above quoted tariff of 4 rupees 80 paisa unit shall be to the seller's account as voluntarily agreed by the seller. My lords, now please see, my lords, there was an amendment to this, just one clause. Please come to 250. I'm claiming, my lords, this is again undisputed fact to say 4 rupees 85 paisa is crystallized. Please see, my lords, at 250. Your lordships will find in the middle quadrant Article 4. Kindly see Article 4 as existing is on the top, which I have read. Please see the modified version, my lord. This is also signed between Bescom and me.
Yes.
Deviations due to system dynamics or unintentional deviations is to be settled between the seller and the procurer, shall be as per the agreed terms in the final balancing and settlement mechanism of Maharashtra or any other regulation applicable from time to time. However, the settlement rate for overdrawal by the procurer, that's Bescom, shall be at the quoted tariff of 4 rupees 85 paisa per unit, and any impact on the same over and above that, my lords, is so 4 rupees 85 paisa is crystallized. Now please straight away, my lords, permit me to come to, my lords, there are multiple litigations back forth. If my friend says it's subject to litigation, I will then read their affidavits before after. I'm keeping it aside for now, my lords, with my lord's leave. Please straight away permit me to come to, my lords, the AG's opinion. My lords, I will read the underdrawal. My friend wants me to read the underdrawal. No, I am grateful. I will read it, my lords. Please come back to page number 250. Mr. Chinnappa wants me to read the second part. I will read that, my lords.
Yes.
Would your lordships permit me to read from the third line, my lords? As second line, my lords, terms of the final balance and settlement mechanism of Maharashtra or any other regulation applicable from Maharashtra from time to time. However, the settlement rate for overdrawal by the procurer shall be at the quoted tariff of 4 rupees 85 paisa per unit, and any impact of the same over and above the quoted tariff shall be borne by the seller. I stop. 4 rupees 80 paisa they will pay. If Maharashtra take 12 rupees from me, then I have to pay the remaining. Now please, my lord, permit me to read the next in the interest of my esteemed friend. He wants me to read it. In case of underdrawal by the procurer, that's Bescom taking less than what it should, the same shall be settled as per the applicable FBSM rate of Maharashtra, subject to the issue of corresponding FBSM account by the appropriate authority in Maharashtra, and to the extent of receipt and realization of the same by the seller. In other words, if there is an underdrawal, that is 100 units they should take, they take only 80. For 20 units, they should actually get the money back. That is, the authority in Maharashtra, which is the Maharashtra Electricity Regulatory Commission, will decide. Then that will be paid to me, the seller, and the minute I receive it, I should give it to him. I have not received a penny, the litigation is pending. So therefore, my lords, the reciprocal scenario is this. For overdrawal, they should pay me. For underdrawal, Maharashtra should pay them, but Maharashtra will pay me and I should pay them. My friends are now setting up the case that we have admitted that for overdrawal, we have to pay 4 rupees 85 paisa. There may be board resolution, but there is underdrawal at some point of time for which we have not got money from Maharashtra through APTEL and you. Therefore, we will set it off. There is no case of set off here, my lords. For the power that is consumed, they pay. For the power that's not consumed, when the accounts are settled, my lords, Maharashtra will pay them. Now, please permit me, my lords, I have given the account saying
So
that
you
I
are
am
now
not
caught in this crossfire.
I am caught in the crossfire and I am out of pocket of 40 crores. My lords, just 2 documents. Please see the AG's opinion, my lords. Fortunately, my lords, it's a RTI document, my lords. Therefore, now, my lords, AG's opinion is at 704. In fact, my lords, a tangential scenario. Because I paid 40 crores and I did not have money to pay my other vendors, I went into insolvency. I went through CIRP process. Fortunately, I'm an MSME. Therefore, the insolvency was resolved and I came back. After my resurrection, I filed this writ petition. My lords, please permit me to straight away. The opinion starts at 704.
Yes.
Please see the question, my lords, at 717. My lords, in 717, the second bullet point. I'm sorry.
Yes.
Whether PCKL should await the conclusion of the proceedings pending in APTEL. That will be my friend's fulcrum saying in APTEL the underdrawal is pending. Whether PCKL should await the conclusion of the proceedings in APTEL against MERC order in so and so. Challenge of the demand made by MSC DCL in terms of the standby agreement. That's the demand, my lords, for 12 rupees. Or petition pending before KERC. Now kindly see the last bullet point, my lords. Whether BESCOM can settle Global Energy's claim amount in part or in full and thereafter await the decision of adjudication of the issues engaged in bilateral discussions. My lords, the opinion straight away, my lords, is at page number 731, bottom quadrant.
Yes.
The learned AG, as it then was, my lords, applies quantum merit principles. And a well-reasoned opinion, my lords.
Yes,
He issues quantum merit and says, please pay because on quantum merit you should pay. My lords, I am at 731, bottom quadrant.
Yes.
Please permit me to read, my lords, the third line in the last bullet point at 731. However, my lords, it starts after FDSM full stop.
There. Yes.
However, since neither the standby agreement nor the power purchase agreement have specified the mechanism for intentional overdrawal, this is a fit situation to apply the principle of quantum merit. Global Energy has paid the cost of overdrawal of power on behalf of BESCOM at the rate of 12 rupees 82 paisa as per the actual charged by Maharashtra State Electricity Distribution Company in accordance with the standby agreement. In providing this service, this is the rate at which it should be compensated under the FBSM, as BESCOM would otherwise unjustly benefit from its actions of overdrawal despite repeated warnings and requests through correspondence from GPL. Having said this, my lords, please see the last observation at 734. My lords, at 734, last bullet point at the bottom quadrant of the page. Please come, my lords, the last 4 lines, the sentence starting appropriate forum full stop.
Yes.
I read from there, my lords, if your lordships
In view
are
of totality.
in view of the totality of the circumstances, it would be fair to opine that Global Energy's claim for overdrawal may be honored expeditiously along with the contractual rate, that contractual late payment charge is not the interest. Well, let's kindly see further. Well, in the issue, in any event, if issues are not settled as per advice of claim, it is certainly advisable as a goodwill measure for BESCOM to at least pay Global Energy at the agreed rate of 485 per unit, if not more. The opinion says pay 12 rupees, that's quantum merit, but at the least pay 4 rupees. 4 rupees. My lords, now this is an opinion, be that as it may. Please come to the, my lords, board resolution passed by BESCOM at 736, annexure BF, my lords.
They accept this?
They accept it, my lords, without demurrer. And they say this will pay the larger settlement after the litigation because they have to pay me 12 rupees. And today, my lords, they plead differently in their affidavits. And they also plead, my lords,
So this is the
only a
board resolution.
Board resolution, my lords, BF at 736. Kindly see certified copy of the resolutions passed at the 87th meeting of the Board of Directors of BESCOM. My lords, this is 2018. Please permit me to come to 737. They quote, my lords, at 737, at the top quadrant of the page, my lords may find within brackets 8, Arabic 8, my lords.
Yes, I am there.
Yeah, the opinion of the Advocate General is as follows. I will not read that, my lords. A, B, they quote it. Then please, my lords, come to the resolution, which is at page number 739, the very bottom, my lords, bottom second half of the page. Resolved that. For the reasons explained, approval be and is hereby accorded to admit, kindly see the words, my lords, to admit the claim of Global Energy for settlement at the agreed rate of 4 rupees 85 paisa for energy overdrawn by BESCOM during the period of power agreement. This approval is subject to the following. Please see the subject to, my lords. And that's what they bask on subject to. At 740, please, my lords, ignore item number 1. That is overdrawn energy account must be given. There is no dispute. Energy accounts will be given. Please see 2. Well, that's important. I'll read that, my lords. 1. The claim of Global Energy for overdrawal and underdrawal energy and scheduled energy shall be accurately ascertained by authentic scrutiny, comprehensive verification by PCAs as per the opinion of the Advocate General. I'll stop here. My lords, this issue of how many units of power has come in. My lords, power is not, my lords, consumed in terms of hourly or daily basis. It is consumed in 15-minute time blocks of every day. and 15-minute time blocks, my lords, the accounts are kept by the load dispatcher. There is a Maharashtra SLDC, which is a state load dispatcher for Maharashtra, and there's a Karnataka load dispatcher, my lords, which is the Karnataka State Load Dispatch Center. They have the accounts. Our bills are based on those accounts of how much power is flowing, because otherwise I cannot bill. Now, please see, my lords, item number, of course, that number 1, my lords, is based on the fact in the previous resolution, my lords, which you saw, that it says settlement at the agreed rate of 485 for energy overdrawn during the period. No problem about it. Whatever energy is overdrawn based on the account. Please see 2, my lords.
Yes.
And this 2 is claimed in the affidavit to say this is incoherent. We have not admitted. Now, number 2, final settlement. Kindly note that word, my lord. This is not interim settlement of 482. I claim 12 rupees. They claim under drawal. 4 rupees 82 paisa is the minimum that is to be paid. Final settlement of deviation account, that is overdrawal / underdrawal, shall be on disposal of pending appeal case, that's before APTEL, and final orders thereon in APTEL. An authenticated and accurate account to be paid to BESCOM shall be ascertained by GM, etc., in coordination with PCKL. Also regarding interim settlement, if any, that's my lords, the 4 rupees editor, made by PCKL, pending final orders, respective appeal petitions filed in so and so. Therefore, if they give me 482, which they admit in their, ultimately, if it is held, my lords, that the 12 must come to me, what is given as 482 will be adjusted. My only prayer, my lords, is this, that in the previous page bottom, there is, my lords, an accord, but there is no satisfaction. In law, my lords, if there is an accord, there have to be a satisfaction. The accord is when they agree in a board resolution that 4 rupees 85 paisa will be paid. My lords, in this slide, two submissions, my lords. ABL International and MP Power Management both indicate, my lords. One, they cannot, there is a defense raised in the affidavit to saying we are an instrumentality of state. If we are an instrumentality of state, then under the constitution, you have to follow the Article 77 mandate, etc. We don't have a sovereign agreement. This is a private agreement. Therefore, you cannot come and claim. MP Power Management precisely answers that question, saying in a power contract, when there is a DISCOM which is state controlled and an instrumentality, they cannot wash away their obligations and they cannot say RIT is not liable. In fact, Supreme Court directs that the payments be made. And ABL International was in the context of a commercial contract.
Yes,
MP Power money is precisely, my lords, on power contracts. And precisely the defense that is raised here saying in a government contract you have to follow 77. Second ground which they raise, my lords, is this is a board resolution. Board resolution is an internal document that does not cast liability. My lords, I have quoted their articles of association. The articles of association of BESCOM says the obligation to pay or the obligation to receive or pay money for services that have been received is all to be decided by the board, and there is a board resolution. It is in that context, my lords, I file a writ petition. The last submission I should make, my lords, is they also raise the ground of delay and laches. My lord, this claim which I made was in 2017, my lords, I raised an invoice. In 2017, when I raised an invoice, they go to the AG in 2018. The board resolution admitting the liability, my lords, is in 2018. Yes. Now, my lords, we are in 2025. Therefore, they turn up and say, how is that a writ petition is filed now? What happened is because money didn't come from me from BESCOM, I went into, my lords, CIRP process in 2019.
That's all right. Money has not come even today.
Even today. The 4 years, my lords, by limitation vanishes because of section 60 of the IBC. I came out of the resolution process, my lords, and became a standalone company in 2020.
If money had come, it's a different.
If money had come, it's a different.
You are claiming something other than that. So yes. Money has not come even today.
This, my lords, is just my submission.
Is the answer? ಇನ್ನೊಂದಿನ ಮಾಡ್ತೀರಾ?
ತುಂಬಾ ಇದೆ ಹೇಳಕ್ಕೆ. ತುಂಬಾ ಅದು my learned friend has filed 4 or 5 volumes, but it's argued only 4 or 5 pages. So
in a nutshell,
ನಾವು ಡಿಸ್ಕ್ಲೋಸ್ ಎಲ್ಲ ಮಾಡ್ತೀವಿ, but only argue, my lords, only what might contain.
In a nutshell.
I'll have to open the nut a little bit more.
Open the nut.
If I was any faster, I couldn't breathe, my lord.
Crack the shell. Correct.
Grateful.
When your lordship's coming next time to Bangalore?
14th, I guess.
Lordships may permit me to appear
online. Yes, Supreme Court. Friday. And Friday.
14 miscellaneous day.
That's why I said yes. We'll take it on 14th. Heard the learned senior counsel Sergeant Pove appearing for the petitioner. The learned senior counsel Dhyan Chinnappa representing BESCOM seeks 10 days time to submit the reply submissions. List on 14th at 2:30 p.m.
Please, very great.
Yes, for further hearing.
17.
Age is waiting. One ನಿಮಿಷ. Shall I run through the list and 2 minutes?
Yes.
ಇದು ತುಂಬಾ ಮ್ಯಾಟರ್ಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂದ್ರಲ್ಲ. ಮಧು, ಐಡೆಂಟಿಕಲ್ ಮ್ಯಾಟರ್ಸ್ ತುಂಬಾ ಪೆಂಡಿಂಗ್ ಇದೆ. So let it come before the regular bench.
No,
But
I
there
was
is a
only
difference in this, so I would, anyway, most of
No,
the arguments.
I was-
Argument ನಾನು ಕೇಳಿದ್ದೀನಿ. But I
wanted
think
to
Raghuram sir said there are many matters pending of this
No, not
kind.
on this very aspect.
No, I wanted to make one proposed submission before your lordship. Number, the Honorable Supreme Court in the armored security
Yes.
cases, though it is possible for the central and the state GSTs to proceed against the same tax assessee, but there are about 4 conditions to be satisfied. Number 1 is they must understand whether it is in respect of the same subject matter, whether the infraction is the same, they must satisfy, consult the state GST, then come to the conclusion. In this case, admittedly, that is absent. If these, and they have simply issued a summons, of course, they have arrested me, etc., when already their assessment proceedings have been complete. So therefore, Mulad, if they want to re-examine the whole thing, keeping in mind.
No, that is not his submission. He will not.
But then lordships may hear
Madhu
the
cannot
matter.
do that.
No, lordships may hear the matter, but I will, because this is also.
Hear
serious-
the matter. There are many other matters.
Those aspects, my lords.
The other day, I think Raghuram sir told.
Those aspects are only.
No, Lord, then Lord, in that case, lordships if are coming back to preside over the bench here on next Friday or something, Lord, I will take about half an hour. Lord, I'll show before your lordships how high-handedly they have arrested me when there has been an assessment order. And then Lord, lordships will declare that arrest to be illegal if lordships are satisfied.
Even it may not be possible.
Therefore, if lordships, I'm told, lordships are next.
14.
Please.
I
My
will
lords,
also file
one more submission. In those matters, prosecution has not been launched, whereas in our matter.
That
prosecution
makes
has
it
been
worse.
launched.
That makes it worse. Armor judgment says you can't go ahead and do it. Therefore, we'll file.
ಕೊಟ್ಟಿದ್ದೀರಾ already?
Yes,
ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ? ಇನ್ನೊಂದು 2-3 ಜಜ್ಮೆಂಟ್ ಇದೆ ಅದನ್ನು
ಅದು
ತಮಗೆ ಕೊಡ್ತೀವಿ.
ಕೊಟ್ಬಿಟ್ರೆ
I will
ಮೊದಲು
give it
next
to
time
them.
ನಾವು
Yeah,
ಓದ್ಕೊಂಡ್
please,
ಬಂದ್ರೆ.
please.
Then we'll keep it on 14th.
Please, lords, please.
List on 14th at 2:30 PM.
Privilege.
Heard the learned senior counsel Prabhuling Nawadgi appearing for the petitioner and counsel Madhu N. Rao representing the GST intelligence. List the matter on 14th at 2:30 PM for the hearing. If it is in the morning, I'll indicate in the morning in the list. itself.
Whatever time.
Please.
18.
ದೇವದಾಸ್ ಸರ್, ಇದು ಅವತ್ತೇ ಮಾಡೋಣ.
But these
ಇದು ತುಂಬಾ ಹೊತ್ತಾಗಲ್ವಾ?
I'm sorry. Judgment citations are there.
ಕೊಟ್ಬಿಡಿ.
Compilation.
Give it.
We have filed our statement. He is seeking for a direction for payment. There they have filed execution petition to execute the award. The execution petition is pending. And meanwhile, my lord, we have also filed miscellaneous appeal challenging the award itself. And notices have been issued.
This has to be heard. It's not.
Yes, in fact, after filing of this writ petition, after taking notice from this writ petition, my lord, they have taken the subsequent remedies of when filing the.
Challenging the execution
Yes. In fact, there is a modification of the judgment passed by the civil court before this honorable single judge of this honorable court. That was not challenged.
I'll take it on 7th. You can appear online. 7th, next Friday.
Very good.
Please.
List on 7th at 3:30 PM.
Please.
Okay.
ಆಗ್ಬೋದಲ್ಲ?
ಆಗ್ಬೋದು, no problem.
This may not get over immediately. Respondent ಇಲ್ಲ ಯಾರು? AG is not there.
Pray, my lords, on 14th.
14th, yes. We'll take it on 14th.
But about 30-40 minutes. If court permits, my lords, I shall prepare.
Permits, you should do it.
No,
sir.
list of, no, so far as citation, synopsis is concerned, only after hearing my learned friend. List of citations, I have
Please,
prepared
please.
it. I shall
Yes.
submit it within 2 minutes from the.
Yes, sir.
From this bag only, it is there.
Yes, sir. He is here already. Yes.
ಅಲ್ಲಿ. Court is there. Yes.
ಅದು ಕೊಟ್ಬಿಡಿ, ನಾನು ನೋಡಿರ್ತೇನೆ ಸರ್. We'll take it on 14th. ಎಲ್ಲಿ ವೇರ್ ರೆಸ್ಪಾನ್ಸ್ ಇಲ್ವೇ ಇಲ್ಲ? ಶನಿವಾರ ಸಾಯಂಕಾಲ ಅಂತನಾ?
ಇಲ್ಲ, ಅವ್ರು ಮುಗಿಸ್ಲಿ, ನಾವು ಒಂದ್ ದಿವಸ ಮಾಡೋಣ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಆಯ್ತಾಯ್ತು, ಸರಿ. Well,
ಇದನ್ನ ಕೊಡ್ತೇನೆ ಅಂತ ಹೇಳಿದ್ರಿ.
authorities could.
ಅವ್ರು ಅಥಾರಿಟೀಸ್ ಕೊಡ್ತೇನೆ ಅಂತಿದ್ರು, ಸಿನಾಪ್ಸಿಸ್ ಕೊಡ್ತೇನೆ ಅಂತಿದ್ರು.
Ella, exchange all that.
ಅದನ್ನ ಕೊಟ್ರೆ ಅದನ್ನು ಒಂದು ಹಾಕೊಂಡು ಅದೊಂದು ಸಿನಾಪ್ಸಿಸ್ ಕೊಟ್ಬಿಡ್ತಾರೆ.
Correct, yes. Exchange all that.
We'll give our written submission.
Exchange all that, yes. Yes, ASG authority.
Other two.
We'll take it on 14th.
With the kind permission. In fact, another two writ petitions were there already filed. Appeared before the regular bench. I requested the court that since the matter is parted here, in spite of I may likely to get an interim order, I said I have already argued and these two matters may kindly be listed on that day.
Tag along with sounds. Ado Greater Bangalore adana adanu.
Same notification.
Yes.
Same, not
tag.
Same notification.
Tag made.
Same notification. They have got the copy also.
Different fruits and vegetables.
Different mallards only.
Same fruits.
Same fruits. And areca nut trees are there. Areca nut trees are there.
All right. Yes.
Pastor.
ಏನಂದ್ರೆ ಜಡ್ಮೆಂಟ್ಸ್ ಏನಿದ್ರು ಕೊಟ್ಬಿಡಿ. Yes sir. Now ASG sir.
Number 9.
I don't know, job ಹೋಗುತ್ತೆ ಅಂತ ಇದ್ದಾರೆ, ಅದಕ್ಕೆ urgency.
Lord, before I address the main issue, let me make a few submissions on the controlled delivery. In 1988, there was a UN convention. Internationally, the illicit trafficking is a big menace. So to identify who are these people who cause this movement of these international drugs, this concept of controlled delivery was derived in a UN convention 1988. Article 11 of that convention deals with that.
Yes.
As a signatory country, we have adopted that, and in 2001, we inserted that. Controlled delivery, Lord, is just one of the investigative tools which will help the authorities to identify. Otherwise, what happens is now in the last couple of decades, one of the easiest methods of ordering drugs is through courier. And when the authorities go to apprehend, they say, sorry, sir, I mean, I have never ordered this. I'm not the person here, or I did not place an order. And that is sufficient in the criminal jurisprudence to escape the nose. Therefore, this concept of controlled delivery was used in order to identify the person. Now, Lord, I may use or I may not use. It is an option. Now, when your lordships pass the order in that Abhay Kumar case, Abhay Kumar case, I think a copy is made available.
Yes.
If I may read just a few sentences.
I think
the lordships primarily refer to the grant of bail order. And after, my lord, page, if your lordships has that order of Abhay Kumar's judgment.
Last time.
I think my learned friend has produced
It
a
is
copy.
here.
Memo dated 1/4/25, my lord.
My lord, page 9, para 10, your lordships refer to the Junaid Hussain Haveri judgment.
Yes.
And then, my lord, in that judgment, in the extract, at the highlighted portion at page 10 and 11, the court which granted the bail noted that the mandatory requirements of 50A were not followed. Mandatory. Now, if I may read para 13 of that judgment at page 10.
Yes, yes.
Learned counsel appearing for the respondent has failed to demonstrate before this court that the officer who had undertaken the excise control delivery with the help of postman and the master of Marthali sub post office were authorized as per section 50A of the NDPS Act. In the absence of authorization as provided under 50A of the NDPS Act, which is the mandatory requirement of law, it cannot be said that the exercise of controlled delivery undertaken by the NCB officers had successfully led them to identify the persons involved in the commission of the offense.
What is the difference between that accused and this accused now?
Both of them were involved. They all connived together. They were all one.
No, but what has happened to this judgment?
Only 2 minutes. No, just 2 minutes.
Yes, yes.
I'm trying to develop an argument.
Yes.
Then it says the NCB officers have recorded so and so. That we can skip. My lord, para 23 at page 11.
No material to show accused.
The para 23, page 11, the last 7 lines. However,
the NCB officers.
Since the NCB officers have not complied with the mandatory requirements of section 50A of the NDPS Act before undertaking the exercise of controlled delivery, the report of the controlled delivery on which reliance has been placed by the prosecution cannot be considered since the exercise of controlled delivery gets vitiated for non-compliance. But I perfectly bow down to this. What his lordship is saying is that if you have not complied with the mandatory requirement of 50A, what gets vitiated is the exercise of controlled delivery. But my lord, where the error has crept is, please have a look at page 12. Page 12. The coordinate bench granting bail clearly holds that the Panchnama would indicate that the NCB has not complied with the mandatory requirement of section 50A before undertaking the exercise of the controlled delivery, and non-compliance of section 50A
Would vitiate the
entire proceedings. My lord, the difference is vitiating the controlled delivery exercise. I'm in complete sync. There is no difficulty.
That would not vitiate the entire proceeding.
Entire proceeding. So, my lord, in that Inayatullah case, your lordships have held that infallibility is not unknown to humanity. Fallibility is not alien to the judicial process. So therefore, my lord, what I thought was,
this is a student, I guess, who will go back to custody.
my lord, these are all serious offences, my lord. They are ruining the society. Your lordship should not shed a tear for such, my lord. These are all serious offences. My lord, this leads to denigration of our youth, who are the future of our country.
I understand, but because
the submission that I'm
no,
making
no,
is,
this man, I don't know about this accused, but this, the accused was a student of the IIM. This is IIM
That
student,
is
right?
accused number 2. That is the accused number 2.
Abhay Kumar. That's what. He was a student of the IIM who was sent out because consumption, not
so,
distribution.
my lord, the evidence on record shows all of them connived together for the purpose of sale. We have got plenty of evidence on that. All that I'm saying is, my lord, I thought, my lord, your lordships have also laid down the law that while review is not permissible, a recall is permissible. My lord, instead of not, I've already instructed in the next 3 working days, my lord, we will present a recall application. Lordship will hear that first, my lord, and then
fine, we'll do that.
Lordship may call this after a week, my lord. Before that, I'll file the application.
7th I'll call.
Yes, great. I'm great.
No, you're basing your foundation is this order.
My lord, my foundation is on law, section 50A.
50A is not complied.
No, my lord.
No, the
argument.
learned ASG said that if section 50A is not complied, it vitiates the controlled delivery process and not the entire crime that is registered.
I just want to read the sections once.
That's all. Yes.
I just want to read the
Okay,
section.
please do. Yes.
My lord, first I'll read section 50A and then go back to section 27B. Section 50A, my lord, power to undertake controlled delivery. The Director General of Narcotics Control Bureau, constituted under subsection 3 of section 4, or any other officer authorized by him in this behalf, may, notwithstanding anything contained in this act, undertake controlled delivery of any consignment to A, any destination in India, B, a foreign country in consultation with the competent authority of any foreign country to which such consignment is destined in such manner as may be prescribed. Now, my lord, section 27B, I'll just... It's part of the order. Section 27B, my lord. Controlled delivery means the technique of allowing illicit or suspect consignments of narcotic drugs, psychotropic substances, controlled substances, or substances substituted for them to pass out of or through into the territory of India with the knowledge, under the supervision of an officer empowered. This, my lord, is important. It has to be read in consonance with section 50A.
That is what is in violation is the coordinate bench judgment in.
Yes, my lord. And my lord, the entire.
The learned AG said yes, there has been a violation of 50A in this.
I concede.
Conceded. Now, the violation of 50A will not vitiate the crime itself. It will only vitiate the controlled delivery process. Are you suggesting that the entire crime is registered on controlled delivery? If the controlled delivery process goes, the entire thing goes.
Yes, definitely, my lord, because my lord, may means the NCB officers could have undertaken controlled delivery or cannot. They have an option either to do it or to not do it. But once the intelligent officer has gone to the post office, has taken the parcel, has cut open the parcel. So, my lord, the object of the NDPS Act is number 1 to regulate. Number 2 is to combat the narcotic drugs. Now they've done this controlled delivery. They've cut open the parcel. They've identified me as an accused. If they would not have done that, everything goes. I would not have even been identified as an accused. So when they have not done that, I would have not been identified. So once they've undertaken the process of control delivery.
Therefore, the entire crime is registered on that control delivery.
Yes.
Of that parcel. And
Yes.
that is in violation of 50A.
Yes, my lord. And my lord, there are 5 accused in this case. Accused number 1 and 2 have booked through accused number 4 and 5. Neither have I booked, nor have I purchased, nor am I into anything. I'm not even in the entire process. I am accused number 3. And my lord, once my submission is, my lord, is this, that once they've cut open the parcel, only then they have identified me as an accused. Apart from that, there is no prima facie substance or any material on record to indicate me or make me as an accused. So they've gone ahead without complying with the statutory protection that the Act provides for me, as for accused number 3. Once they've done that, they should have complied with the provisions, my lord. Director General is the empowered officer under Section 50A. They have gone ahead, done the entire process. They've utilized Section 50A without maintaining the statutory compliance of what the section provides for, and Section 2 subclause 7B. So once they've identified me as an accused, now to my lord, come and see.
ASG sir, there's a point in what she says.
Lord, let me answer that.
If everything has sprung only from that parcel and
that's an incorrect submission.
then what material do you have other than the parcel? What material do you have?
Other materials, the seized material, seized phones.
No, that is after that. The
communication
corroborative material is what you are
No, the
relying
communication-
on. The basis of foundation for complaint.
No, independent of the control delivery, I have got other evidences. Lord, the prosecution should be sustained on the basis of other evidence that I have. Lord, 482 cannot be used by the petitioner to evaluate the strength of that evidence. Lord, that is
No,
settled.
the problem is there is already an order. That's the issue.
My lord, I just want to point out.
Lord, the other judgment, not the recall application, may be heard independent of that. And then this may be taken up. If my learned friend wants to argue that independent of that judgment, I am ready even now.
No, she's wanting to do.
I'm wanting to argue, my lord.
That's what she's done. Till
No,
now.
I mean,
I just want to point out one thing, my lord, within the bail order. I'll just pass on because I've not made it part
Bail
of
order
the.
ಇದೆ ಇಲ್ಲಿ.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿಲ್ಲ. Compilation ಅಲ್ಲಿಲ್ಲ.
ಆಯ್ತು ಕೊಡಿ bail order. ಅಲ್ಲಿ AG ಸರ್ ಕೊಡಿ.
It is extracted in your lordship's judgment in the.
The para 1213.
Not all of it, my
The
lord.
critical part is already extracted.
Whatever, letter, yes.
And my lord, the threshold for bail and for quashing are way different. There is a world of difference between them.
I agree, my lord, and I agree to senior's argument saying it's an investigative tool. But when it's an investigative tool, they have an option to either to use it or to not use it. But once in NCB officers have undertaken control delivery, they must give me the statutory protection. They cannot just go ahead, cut open the parcel, identify me as an accused, and now to come and say that it's an investigative tool. Yes, it's an investigative tool, but to what extent? I am accused number 3. Your lordship's order has attained finality. And my lord, this bail order, your lordships may kindly see, my lord, internal page number 7, para 5. Shri so-and-so learned senior counsel appearing for accused number 3. Same facts, and my lord, the statement of objections that have been produced by, this bail orders with respect to the accused number 3 who's before your lordships now. And the statement of objections, my lord, I'll get into that later, but para 5, my lord, page 7. Appearing for accused number 3 submits that the parcel was opened in the post office by NCB officers even before apprehending any of the accused, and the contraband article allegedly found in the parcel was subjected to Panchnama. Thereafter, dummy parcel was delivered to accused number 2 and 3 respectively, and they were apprehended. My lord, this part is important, where the court has identified and already gotten into this aspect that I was not even identified as an accused even before they cut open the parcel. So the fact remains that I would have not been a part of this entire case if they, or I would have been, but the point is that they should have followed the statutory compliance of Section 50A.
That is what.
And my lord, otherwise, my lord, I wouldn't have been identified as an accused. There is no other material for them to identify me as an accused. Only after they cut open the parcel, they identify me as an accused. They tell accused number 2 to go with the NCB officers and then to deliver the parcel. That's the chain, my lord. Otherwise, the entire process would not have occurred. They wouldn't have even known. And my lord, out of 5 accused, I had nothing to do with the entire transaction. Accused number 1, 2 have booked through accused number 4 and 5. And accused number 2 has paid for this narcotic drugs through crypto.
how did you come into the picture?
Only when, so
No, what is that material that was there for you to be dragged into the picture?
it was the name on the parcel, my lord. They said that this
Name
needs
on
to
the
be.
parcel.
Yes, so
Name on the parcel was yours.
name on the parcel was mine. But how did they get to know, my lord? Only once they have started the process of control delivery. The one Mr. Siva Rao, who's the IO, who's gone to he's received the credible information that certain drugs have been sent from Coimbatore to Marthali sub post office. He has recorded that information, gone to the post office, informed the postmaster and the postal assistant. Requested them to be independent witness. So while he's doing all this, he could have just done one more thing, taken the authorization of the DG.
Oh, admittedly, authorization of DG is not there.
No.
No, my lord.
That he accepts.
Yes.
My lord, may I just pause here for a moment, because I think we will unnecessarily waste energy. If my learned friend says that we have filed the complaint only on the basis of the courier delivery, she is wrong. In fact, she has produced a copy of the complaint, the prosecution complaint. Please have a look at that complaint, which is produced in volume 1. It begins at page number 23, but then the relevant part, which I would like to take your lordship, is at page 49. Ink page 49, Roman number 27, internal page number.
49, is it?
49, at the bottom para 4, my lord.
La complaint ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
Complaint filed by learned friend, along with the writ petition,
One, my lord,
the criminal
part of the
petition.
Lecture B, page 22.
Yes, it starts at 22. The seniors reading from page 49.
49.
Page 49. Internal page, Roman 27. Lordship got it? At para Roman 3, the complaint refers to telegram chats. Similarly, it continues at para 4. The transcripts of WhatsApp chats between Junaid Haveri, which is the British petitioner of your lordship, and Abhay Kumar, the other one, so and so, it refers to the various discussion. And on the next page, from the above chats, after the portion that is in bold, from the above chats, it is clearly indicate that Junaid Hussain Haveri, which is the petitioner, and so, are into sales of HSD, LSD, and other drugs. Junaid Hussain Haveri instructs so not to procure that so. So it is not based on the parcel alone.
So even A3 was not, A3 was selling.
All of them, my lord, discuss selling. All these accused have telegram accounts where they discuss selling, and we have about 1,000 pages of the transcript, and their bank accounts also corroborates this. So the bottom line is, we have got evidence and proof which is acceptable in law, but I should be permitted to establish my case. If my learned friend's case is, number one, she says once you undertook 50A, then you cannot proceed. Where is that law, my lord? I do not find any such law. Let her furnish any authorities. Number two, that my prosecution is only based on the courier. No, it is based on other proof. No, lordship will envisage this situation. If this very petitioner had approached your lordship, if had not conducted the controlled delivery, would your lordship interfere? The answer is no. So therefore, the control delivery being only an investigative tool, which I may or may not use, if I had not at all used, how would it, then your lordship would not have interfered, because my complaint indicates an offense. If we apply the Bhajanlal principles, my lord, not a single of the 7 elements would be satisfied. The complaint clearly makes out a case. So I should be given an opportunity to prove the trial, improve in the trial.
My respectful submission, my lord, I don't have to rely on authorities. The law protects me. Section 50A is the law, and as on today, the law, it is the law that needs to be followed. If the argument is that your lordships would have not interfered, if Section 50A was followed, that's exactly my case. Now that it's not followed, your lordships will have to, since your lordship's order has attained finality, with respect to the very, and one more thing.
On following the law, I need to understand. When my learned friend says I have not followed the law, I need to understand what it is. If her case is that it was not authorized, my lord, I agree. So therefore, the control delivery process gets vitiated. But her proposition that she is trying to lay before your lordship is that once I initiate 50A, then I cannot go to other proof. It appears to me that is the proposition.
Just one more thing I want to point out. The WhatsApp chats that were just referred by my senior, just at page, the coordinate bench's order, my lord, at page 22, para 20, if your lordship's in fact.
Yes.
Internal page 22, my lord. It's a separate.
Anyway, no, my lord,
20,
482 cannot
20.
use
Accused number
evaluate the
one.
evidence.
20, my lord.
Accused number one. Begins with accused number one, is it?
No, no, my lord. From a reading of the voluntary statement of accused number 3.
Justice Shetty or order, alva?
Now what's been relied upon is the telegram and the WhatsApp chats, my lord. I just want to point out
Paragraph yavudu?
20.
20.
Yes.
From a reading of the
From a
voluntary.
reading, yes, my lord. From the reading of the voluntary statement of accused number 3, it is seen that the alleged WhatsApp conversation was with respect of a parcel which he had received earlier, and the same was kept by him near front of door window of a villa, and it was picked up by somebody. Therefore, it is very clear that the WhatsApp conversation of the extracts are placed on record by the prosecution do not relate to the present transaction. The learned counsel for the respondent has failed to demonstrate before this court that WhatsApp conversations are placed on record in any way relates to the present transaction and is not with respect to the earlier. There is, and my lord, the last part of para 21. There is nothing on record to show that accused number 2 and 3 knew the contents of the parcel which was ordered by accused number 1 in the name of the accused number 3. Accused number 3 is only the addressee of the consignment, while accused number 2 had allegedly transferred the amount to Swapnil Joshi through cryptocurrency account as per instruction of accused number 1. It is only the accused number 1 who knew the contents of the consignment / postal parcel, as he was the person who had placed the order through telegram. So this is already covered, my lord. This is all argued. And my lord, this honorable court has already quashed the proceedings with respect to accused number 2.
Parameters of examination, bail and for it.
And also, my lord, this was at the crime stage. The investigation was going on. FSL report was not there. Now, my lord, we have completed the investigation. We have the benefit of the FSL report.
We'll see.
And my lord, in my memo, just on parity, my lord, because I stand at a better footing. Accused number 2, my lord, was the one who booked the parcel, and your lordships have quashed the order quashed the proceedings with respect to that person. And my lord, had nothing to do with it. Only when I was identified as an accused and the parcel was delivered to me, they have made me an accused number 3 in this particular case.
That is not.
And my lord, Supreme Court, my lord, has held that once it's part of the memo. I'll just read that paragraph also. The principle of parity in criminal cases that where the case of the accused is similar in all respects, which, my lord, in this case, it's arising out of the same crime number. I'm not even the main accused. I have not booked, I have not purchased, I had nothing to do with it. The NCB officers have very conveniently skipped the entire statutory protection that was supposed to be complied with. Section 50A, as on today, is the law, is not being followed. So that's why, my lord, I'm relying on this case to say that in criminal cases, my lord, where the case of the accused is similar in all respects as that of the co-accused, then the benefit extended to one accused should be extended to the co-accused. With regard to this principle, it is important to mention the observation of this case and please, ma'am.
Not the statutory protection under 50. I have not understood what it is. The learned friend said that.
Procedural protection.
Procedural protection.
DG's permission had to be taken,
Fine.
not taken.
I am willing to forego. I am willing to forego the activity of control delivery. My control delivery has gone to the dustbin now. I am not going to use it. But I have other evidence which should sustain my prosecution.
Let them also throw me also on the dustbin, my lord. Like let them forget about me, because I'm only the accused number 3 in this case and I have nothing to do with it.
Lord, we have to save this country. We are not going to do that.
No, that's not that. But by way of procedure, that's all.
By way of procedures, no.
Yes.
But I will file that application.
Other separate will pass this out.
This will not.
No, independently she has done.
No, are your lordship treating this as heard?
Yes, heard.
I have one written submission. It is ready. I may pass on.
I've served.
Lord, I am relying upon a couple of authorities. The proposition is that error in investigation, my lord, there are 2 Supreme Court judgments. Error in investigation cannot result in acquittal. I am at a much lower threshold. Error in investigation cannot lead to even washment.
Learned seniors, sorry.
Number two, my lord, that I have referred to Niharika as well as Bhajanlal to show that I have made in my complaint demonstrate that an offence is committed, that is sufficient. The other parameters are not justified.
Learned seniors, the judgments, my lord, just a rejoinder to those the judgments that are relied. Either soft copy. The judgments that are.
The judgment offense.
No, sir, I know. They've served a soft copy already.
ಕೊಟ್ಟಿದ್ದಾರಾ?
Yes.
Okay.
So now those, my lords, my rejoinder to those judgments are, everything deals with the fact that 50A is an investigative tool. For one moment, I'm not saying that it is not an investigative tool. My submission, my lord, is this. It is an investigative tool. The NCB officers have the option of either going ahead with it or not.
You told me.
Please, my lord.
The Delhi High Court, my lord, refers to 50A as a directory, not mandatory.
That is, we'll
But-
consider,
But my
we'll
submission
consider
is, my lord,
everything, and
it
if
is.
in case I've committed a mistake in that, we'll try to rectify.
Anyway, I will file that application also.
Yes.
Abhay Kumar's case. I'm grateful to you.
Please, my lord.
Heard Counsel Srimati Kirti Reddy appearing for the petitioner, learned Additional Solicitor General Sherwin Kamath, reserved.
I'm so grateful, my lord.
Yes.
Pastor 7.
First, sir.
Sir, please, your lordship.
Yaudidu? Day before yesterday's matter.
Day for yesterday's matter.
Ah.
Lord, here. My lord, this matter, my lord, crime number 118, my lord, of High Grounds Police Station, that Valmiki
ಅದೇ,
Nigam's.
I have passed an order. ನೀವು ನೋಡಿದ್ದೀರಾ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಏನು ಅಂತ? You not have
ಅಲ್ಲ,
the price?
that matter is, I think, different. My
It's
lord.
not this matter, no entry matter.
This is different, your lordship.
No,
Lord,
special court transfer ಮಾಡೋದು is illegal.
Yes, yes.
That's the thing in this.
Yes, yes. Same.
No, that I have seen, your lords. In fact, your
Ah,
lordship's
this
order
you
on
have seen.
CBI matter, my lord.
A CBI matter.
I have the judgment, I'll place it. In fact, there your lordship has dealt with this issue.
Yes, sir.
My lord, this case, my lord, that charge sheet was filed by SIT, CID, SIT.
Yes.
Cognizance was taken. My lord, after cognizance was taken for the offences, my lord, under section 409, 468, 471, which are all trial by magistrate, your lordship. My lord, at that stage, my lord, that correspondingly, the CBI had taken up investigation, my lord, in respect of bank officials. That was, my lord, in RC
The other
78.
matter where
That is another matter. Lord, when that being the case, my lord, that a letter was given, my lord, by a police officer stating that facts discloses commission of offence under Prevention of Corruption Act. It's not the opinion of investigation officer in the final report. Court has already taken cognizance. No permission for further investigation was taken, nor it is in the course of further investigation, another supplementary report was filed. It is only a letter, a requisition. Requisition bringing to the notice of the magistrate that the facts may disclose the commission of offence under Prevention of Corruption Act. On filing this application, the magistrate transferred the records to portal number 24. Now, the difficulty faced by portal number 24, which is a special court, my lord, under section 4 of the Prevention of Corruption Act, without an order being committal, the court itself has to take a cognizance. That court did not take the cognizance. The another difficulty was there was no sanction to take cognizance against this public servant. Since 1 year, 1 month, your lordship, that the same
Going on.
status is going on. Meanwhile, what happened, your lordship, as on the date of transfer of that case, only this petitioner was released on bail by High Court, upon which, my lord, the petitioner got released. Thereafter, that portal number 24, which has no jurisdiction to touch this file at all, merely because it was transferred, the bail application also was filed there, remand application was filed, remand order in respect of other accused who are in
All
custody.
orders are passed by that court.
All by passed by it even today. And this petitioner was asked to be present every date of hearing. We submitted that once the charge sheet is filed, cognizance is taken by the magistrate. This court cannot deal it. If this court has no jurisdiction, please don't insist to be present. Hajarate, insist madongela anta. But that was not considered at all. Every date of hearing, my lord, present petitioner used to appear, date being given. No progress at all because that court neither can take cognizance nor can proceed with the trial. Now, our ground for quashing this petition, my lord, is in the charge sheet filed by SIT CID, the role, my lord, assigned to this accused, my lord, he did not gain any money. no money has come to his account. In respect of accused number 1 to 11 is concerned, out of 80, my lord, 84, my lord, which was swindled away, my lord, 5 lakh was retained, 79, my lord, 79
No,
crores.
that's
amount.
on facts.
Facts, my lord. That
Now, on law,
It
the
cannot
only
be-
thing is that the special court cannot take up this because it is to be tried by a magistrate. They're
It
all
should-
420,
yes, yes.
407
It
offences.
should go back to that
Merely
court.
because some accused
Yes.
has Prevention of Corruption Act allegation against them, it can't be transferred against others, is what you say.
No, not like that, Your Lordship. Lordship may kindly see, my lord, formation of opinion, my lord, after investigation is the prerogative of investigation officer.
Correct.
He forms an opinion under 173(2) or, my lord, that in BNS, my lord, that 198, my lord. Now, this formation of opinion for offences tried by magistrate. No further investigation was taken up.
No further investigation.
No formation of second opinion was by the
Fact,
investigation
on fact,
officer.
Sorry, my lord, on fact, which is wrong. Your lordship may take up page 422. I'll show it from the charge sheet which placed by them. Permission was sought for further investigation.
Yes,
Permission
yes.
was granted.
So-
During the course of investigation, approval under section 17 was obtained. Thereafter, based on approval of 17 was obtained.
This petitioner is a public servant.
He is not a public
No,
servant.
the others
With
are
respect to
public
others.
servant. Ah.
Therefore, matter was brought to the knowledge of the court saying that since now we are investigating the PC Act, this court may not have a jurisdiction.
It has to be
Therefore,
transferred to special court.
That's all has happened.
My lord, the letter, my lordship, may kindly, after cognizance, my lord, it cannot be. This, your lordship. This is very important.
Yes.
My lord, once the final report is filed, any report, my lord, thereafter, it could be in continuation of main report. Vinay Tyagi's case, my lord, that what is further investigation? My lord, if by virtue of a report under 173(8) discloses commission of the offence, then they have to file a report. Report under 173(8). 173(8) report is not filed. By giving some officer a letter case, my lord, the jurisdiction of the court itself being transferred. This is not permissible, your lordship, may kindly see.
Yes.
My lord, order sheet, your lordship, I will point out, your lordship. Kindly page 198, my lord. It is not by filing any report. No supplementary report was filed. Page 198.
Clean the
my lord.
office note and record forward.
Yes, my
court
lord,
letters.
office note, office tippani.
As per
and
order
others.
of the honorable.
Yes, yes. Only one sentence. This left side note, my lord, is only a letter given by some police officer, DYSP. Not on the basis of any
Who is
report.
the public servant here?
There are multiple people.
25. Multiple.
Multiple people. At
Lord,
least 4 and 5 are the corporation employees. And there are other peoples also which.
Out of the accused, my lord, here, only one, my lord, that I think this, lordship may kindly, this accused number, Parshuram and Parshuram and Padmanabh, A5 and A6. A5 and 6, who are the managers of this Valmiki Nigam. They were said to be public servant. But the
A3
question,
and
my
A4.
lord, that right from the inception of FIR, Prevention of Corruption Act was not invoked, and opinion of the investigation officer also was not for the offence of Prevention of Corruption Act. Cognizance also was not taken. Now, my lord, that during the course of further investigation, if at all, if it had been done, report should be submitted under 173(8). It should be a continuation of main charge sheet. My lord, what further?
Now what is the impending threat?
Nothing, neither that court can take the cognizance, not this court. Now your lordship has to set right this.
Correct.
Otherwise, my lord, no progress is possible, it is.
That's correct. You have objection,
Correct.
Hakpaka?
I'll file my objection. In fact, my lord,
Good evening.
your lordship judgment, my lord, deals with the issue of non-IPC offences, jurisdiction of this, the special court. And your lordship may see at charge sheet, at the end of the charge sheet itself, we have stated that further investigation is pending, and their claim that further investigation cannot exceed from what it is. I think it's unheard of, my lord, because
This is not challenged?
that has not been challenged.
At cognizance, your lordship may kindly see the order, my lord, cognizance taken.
ಅದು reason ಇಲ್ವಾ?
Nothing, your lordship. A magistrate has taken cognizance. My lord, page 170, lordship. This order, my lord, that discloses commission of offence, which are all trial by magistrate. We are not disputing to this stage.
All right, you file your objections. We'll take it on 7th.
Now,
Next-
can the
next Friday.
magistrate transfer it? It is not a committal.
Correct, it's not a committal.
Not a committal. Transfer to Kotal 24 and 24, what section 4 says, my lord, under prevention of
Is
corruption.
the special court of session in this case?
Yes, ma'am.
Yes, special court of session, but that court has not taken cognizance for Prevention of Corruption Act.
Because charge sheet we
My
are
lord,
going to
the
file.
question is, magistrate also cannot take cognizance for it. Magistrate
No,
has
PC
taken,
Act, admittedly, he cannot take.
he cannot take. Now cognizance is taken for these IPC offences which are tried by magistrate. My lord, now at present, my lord, that the total 24 also not taken cognizance.
Somebody should take.
Yes, some.
We have to file a report.
ಇಲ್ಲ ಏನ್ ರಿಪೋರ್ಟ್ ಹೀಗೆ ಒಂದು ವರ್ಷ ದಿಸ್ ಈಸ್ ಮೈ ಲಾರ್ಡ್ ದಟ್ I'm hesitating to disclose some fact in this case.
No, only thing, my
It
lord.
is this the most unfortunate it is, whoever it may be, my lord, that irrespective of this accused and all that, my lord, this is something suspicious at the hands of someone, my lord, that the file is taken out from the roll from the court of magistrate and placed before that particular court. Everything is maneuvered for some purpose. I'm
No,
not
no,
disclosing this.
then I can also
I have
say-
the
then I can-
information.
No, then I
but
can also
I don't
say,
want to
no, I
disclose,
did
your
not
lordship.
open my mouth. I can also say, my lord, that it is unfortunate we did not challenge the bail granted to him by
Yes.
this court. And
Yes.
the bail was granted to him by this court by suppressing various
Thing
material
is, no, you
facts.
cancel it.
We
You
did not
cancel
challenge
if
it.
it is
It's unfortunate
permissible.
we did not
It is the
challenge
High
it,
Court
but
which
it
has
suppressed
granted bail.
material facts,
My order.
not yours.
It is the High Court which has
It
granted
is
bail
with
for
suppression of
him.
material facts.
I am not saying that of this petitioner. This petitioner was granted bail by this court. My lord, that has been accepted by him. But the order passed by this Kotal 24, which has no jurisdiction.
That will consider.
This, my lord, that there something has happened. I'm not, my lord, I don't want to say.
Legally will do. Will legally
I
answer
am
it.
not, my lord, on that. I'm not hampering it, only bringing to your lordship kind notice.
We'll see.
The
Yes.
air is revolving on that. That air,
List on-
smoke was revolving for what
List on
purpose?
7th. ಅಷ್ಟರಲ್ಲಿ ಹಾಕ್ಬೋದಾ?
My lord, meanwhile, my lord, some protection. My lord.
ಈಗೇನು ಒಂದು ವರ್ಷದಿಂದ ಏನಾಗಿಲ್ಲ ಕೋರ್ಟಲ್ಲಿ ಏನಾಗುತ್ತೆ ಈಗ?
Otherwise, it will go on like this.
We
Your
will see.
lordship.
Well, 7th will pass some order. Let him
Because
file his
now this
objections.
being a predicate offense, the ED court, my lord, is taking note of. That's how it is.
I can't stay this on
No,
that
not,
reason
I'm not
unless
seeking for ED court. If this is, my lord, some, my lord, pending disposal, my lord,
next Friday we will grant. Yes, list on 7th.
lordship will be in Harvard court, my lord.
No, online, sir.
File will not reach, my lord. by
It will. Don't worry about all
It
that.
is your
This time that will not happen. Yes.
Oblige.
Yes. Madam, date give.
13.
ಅಲ್ಲ ಇದು 2 acres ಐಡೆಂಟಿಫೈ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರೆ
ನಿಮ್ಗೆ ಮ್ಯಾಕ್ ಇದ್ದಿದ್ದೇ ಗೊತ್ತಿರಲಿಲ್ಲ. ಸಾರಿ ಕೊಲೀಗ್ಸ್
ಹೌದಾ?
ನಾನು ಅಪೇರ್ ಆಗಿದ್ದು ಗೊತ್ತಿಲ್ಲ. ವಿ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಅನ್ ಅಫಿಡವಿಟ್ ಬೇರ್ ಮೈ ಪ್ರಿನ್ಸಿಪಲ್ ಸೆಕ್ರೆಟರಿ ಸೇಸ್ ಕೊಡಕ್ ಜಾಗ ಇಲ್ಲ, ದಾರಿ ಇಲ್ಲ.
ಹಂಗಾರೆ ಇದು ತಗೊಂಡ್ರದ್ದು ಕೊಟ್ಬಿಡಿ ವಾಪಸ್.
Principal affidavit filed by the DC is principal secretary has directed me to say that there is no land. Certain lands are available that is required for us. And ಒಬ್ರಿಗೆ ಕೊಟ್ರೆ ಬೇರೆಯವರು ಎಲ್ಲರಿಗೂ ಕೊಡಬೇಕಾಗುತ್ತೆ.
ಇದು not correct.
And when the court says give.
It is not correct
But
at
I have
all.
also tried
We'll have
my
to pass some order against such
I have tried my level best to convince them to say that
horrendous
out of 4
directives.
acres, 2 acres forest ಅಂತ ತದನಂತರ ಕೇಳ್ತಿದ್ದಾರೆ.
ಯಾವಾಗಿಂದ ಫಾರೆಸ್ಟ್?
Right from 1930s is what we have stated, not.
ಈ ಗ್ರಾಂಟ್ ಮಾಡಿದ 4 acres.
My lord,
2 acres ಮಾತ್ರ
grant was done, my lord, in 6/5/1967. OD, my lord, is done in 2014. Now, my lord, on 9. My lord, OD is also done in 1967.
ಮತ್ತೆ ಈಗೇನ್ ಪ್ರಾಬ್ಲಮ್?
Now, my lord, 9/7/2015, after 45 years.
They say it is a forest land.
They say, my lord, that 39 guntas was forest land. Then, my lord, one more survey was done where it says nothing, my lord, nothing is forest. Third, my lord, they say 4 acres was forest. Therefore, we came before your lordships. Your lordships directed, my lord, to do a survey. 2 acres was, my lord, they said now.
ಈಗ 2 acres ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
My lord, 2 acres survey, 2 acres ತೊಂದ್ರೆ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. Then, my lord, we made a statement before your lordships. Though, my lord, there is a house to give quietus to all this. 2 acres alternative land ಕೊಟ್ರೆ we will leave the house also.
Correct.
Therefore, this honorable court, my lord.
ಈಗ ಅದು ಕೊಡಕ್ ಆಗಲ್ಲ ಅಂತಿದಾರಲ್ವಾ?
Now, my lord, the
ಈಗ
affidavit.
ಪೊಸಿಷನ್ ಇದ್ದೀರಾ ನೀವು?
Yes, we are in possession.
ಆ 4 ಎಕರೆ ಬಿಡದೇ ಇಲ್ಲ ಅವರು.
Understand, my lords, but
We will see how we will drive them out.
no, lords, it's not about.
No, this is not correct.
Of the 1935 notification.
What 35, 1967 ಗ್ರಾಂಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಏನಾಗಿತ್ತು? ಪೋಡಿ ಮಾಡ್ಬೇಕಾದ್ರೆ ಏನಾಗಿತ್ತು? Your officers have done that, sir.
Lord said directed me to keep the officers present.
Then-
Tamunde bandidru, they also made the very same submission.
Then you can't, how can you do this?
I understand.
ಯಾರು
but then-
45 ವರ್ಷದಿಂದ ಕೊಟ್ಟಿರೋ ಲ್ಯಾಂಡ್ ನ ನೀವು ಈಗ ಫಾರೆಸ್ಟ್ ಲ್ಯಾಂಡ್ ಅಂತ ಹೋಗಿ ತಗೊಂಡ್ಬಿಡ್ತೀನಿ ಅಲ್ಲ, ಒನ್ಸ್ ಎ ಫಾರೆಸ್ಟ್ ಆಲ್ವೇಸ್ ಎ ಫಾರೆಸ್ಟ್ ಕಾನ್ಸೆಪ್ಟ್ ತರಬೇಡಿ ಇಲ್ಲಿ.
ಇಲ್ಲ ಅರ್ಥ ಇಲ್ಲ. What we are trying to say is by mischief of some officers in the year 1965.
What to do, sir, is perfected his rights over it.
I understand.
A person who is in 4 acres possession for the last 45 years, now you non-suit him. On what? On a spacious plea that some officers have played mischief in 1967?
Appears so, my lords, but then.
What, sir? This is not correct at all.
I can only make a request, my lord, to pass an order, my lord, because I
That
have
will
tried-
pass. This, I think we have to pass an order.
Yes, my lords, because I have tried my level best to convince my officers.
And your lordship may see the affidavit now filed. Though court said give alternate, he says principal secretary had directed me, so I will not. So my lord, for him, not the court's order which is important.
We'll have to observe all that. We'll pass some order. Post it on 5th for dictation.
Please.
Yes. List on 5th.
Sorry, I couldn't be present.
ಅವತ್ತೇನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಲ್ಲ,
ಇಲ್ಲ.
ಅಲ್ಲಿರ್ತೀನಿ, ನಾನು ಮಾಡ್ತೀನಿ. ಐ ಆಮ್ ಅವೇರ್, ಅಲ್ಲಿರ್ತೀನಿ. ಯಾವತ್ತು ಹಾಕಿದೆ ಮೇಡಮ್? 7th ಬರ್ಲಿ ಬಿಡಿ. 14th ಆಯ್ತು, 14th ಬರ್ಲಿ ಆಯ್ತು.
ಹಿಂಗಿದ್ದಾಯ್ದಿಲ್ಲ.
ಇದಿಷ್ಟು ಆಡ್ ಮಾಡ್ತೀನಿ ಬಿಲ್ ಕೊಡ್ತೀನಿ ಅದನ್ನ ಜೇಬೈ ಕಳಿಸ್ತೀನಿ ಅವ್ರದ್ರಲ್ಲೇ ಓಪನ್ ಮಾಡ್ಬಿಟ್ಟು ಅವ್ರಿಗೆ ನಾನು ಅವ್ರಿಗೆ ಅದು ಕೊಟ್ಬಿಡ್ತೀನಿ ಕಾಫಿ ಅವ್ರ ಅದನ್ನ ಅವತ್ತು ಡಿಕ್ಟೇಟ್ ಮಾಡ್ತೀನಿ ಡಿಸ್ಕೌಂಟ್ 5 ಲೆವೆಲ್ ಟೈಮ್ ಬೇಡ ಅಂದ್ರೆ ಗೊತ್ತಿಲ್ಲ, ಆಮೇಲೆ ನೋಡಿ ಆರ್ಡರ್ ಗೊತ್ತಿಲ್ಲ.
ನಾನು 35 ಕಿಲೋಮೀಟರ್ಗೆ ಕೇಳಿದ್ದೀನಿ, ಹೇಳಿದ್ದೀನಿ. ನೀವೊಂಚೂರು ಫ್ರೀ ಆದಾಗ ಬಂದು ಬರ್ಕೊಡ್ತೀರಿ. ಅಲ್ಲೇ ಹೇಳಿ
ನಾನು ಒಂದೊಂದು ಹೇಳಕ್ ಆಗುತ್ತಾ?